afternoon. Senate Judiciary and Public Safety Committee will come to order. Today is March 16, 2026, and we do have a quorum present. Members, our hearing is hybrid today for those who were not easily accessible because of the storm and road conditions. We want to make sure every member is able to participate, so we'll pay attention to that. I hope I will remember to pause so those who are online, if we have a vote, please be prompt in unmuting yourself, going video on for votes, and then we'll have all the proper decorum taken care of. Just remind folks about the decorum requirements as well. We're expecting people to adhere to standard expectations and decorum of the committee. I think it's in writing in the back of the room as well.
Get my eyeglasses
but
in my folder.
Anything else that I add, if there are any disruptions, of course, folks may be asked to leave the hearing room. So that way everyone who testifies is shown appropriate respect for their viewpoints, even if you disagree with it. We're going to start with Senate File 3622, Senator Kreun. Why don't you go ahead and introduce your testifier when you're ready. If you'd like to make some opening comments about the bill, go ahead. This is the first committee stop for the bill, and I understand that there is an A1 amendment. If that's an author's amendment, we can take care of that right away.
Yes, thank you, Mr. Chair. This is a bill that amends the Minnesota Common Interest Ownership Act, which I might sometimes call MKIWA. I do have an author's amendment. I can briefly explain that if you'd like.
Well, it's an author's amendment. We're going to be adopting it anyway, so you can explain it as a part of your whole bill. How's that?
Very good. Thank you, Mr. Chair.
Senator Kreun moves adoption of the A1 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Kreun.
Thank you, Mr. Chair. I will try to be somewhat brief. This is a very large bill in terms of number of pages, but the vast majority of this bill is technical and conforming changes. The vast majority of the sections are non-substantive, so I will focus my comments on the substantive changes to the Minnesota Common Interest Ownership Act. This is the result of the Minnesota State Bar Association real property section and the MKIWA subcommittee within that section. These are attorneys who represent all stakeholders in common interest communities, developers, association, unit owners. This is a very balanced bill and hopefully not controversial. There is a one-pager from the Bar Association, I believe that's in your packet. I'll use that as a guide to walk through the bill just on the highlighted points. I will take them a little bit out of order. Section 1 of the bill, which is the third bullet point on this one-pager, is the common interest communities that are created primarily for the purposes of creating or modifying rights with respect to access, utilities, parking, ditches, drainage, or irrigation are exempt from the requirements. So it's unclear, under the current law, it's unclear if the exemption is nullified, if such projects add to the declaration provisions regarding property insurance and repair or replacement processes. This bill simply clarifies that in such situations, the exemption continues to apply. Then, Mr. Chair, we'll go to section 3 of the bill, which is the 6th bullet point down. This really just, I won't go through all of it. It just provides more certainty regarding when a recorded affidavit is sufficient evidence. There's certain affidavits that have to be recorded when there's been consent of the requisite number of unit owners. This just clarifies when that's necessary. Section 4, which is a really interesting part, that's the first bullet point. I was informed by my testifier this morning that this was already in the general court rules. Now we are just putting it into the statute so nobody makes a mistake. That condominium CIC plats cannot be both Torrens and abstract property. They have to be one or the other. Then we'll go down to section 12 of the bill, second to the last bullet point. It clarifies that for an amendment to a declaration or supplemental declaration to be effective, is necessary to record both that amendment or the supplement and evidence or consent or approval if required by the declaration. That's in lines 2822 to 2824. The next substantive section, another one in section 12, another is that it clarifies that an amended plat is not required solely because the declaration amendment converts a common element to a limited common element if 515B does not otherwise require that the limited common element being created be depicted on the plat. That's line 2826 and 2827. Then section 18 is the next one. That just simply says that CICs can have fewer than 3 members if there are less than 3 units in the CIC, so that's pretty self-explanatory. Then the next substantive section is section 25 that allocates costs and risks by allowing CIC's governing documents to obligate the owner of the unit to which the limited common element is allocated to maintain primary liability insurance. I understand my testifier might know more about this, but that would be like perhaps a restaurant or some other commercial interest that is included in the CIC. They would have the primary liability insurance rather than the association as a whole. Then the A1 amendment, Mr. Chair, that's found in section 28 of the bill. I believe that's on page 70. This simply defines what a first mortgage is under the MKIWA. So right now, the assessment lien of an association is subordinate to a first mortgage, which makes sense because we want owners of CIC units to be able to get financing. So you want the assessment lien to always be subordinate to whatever the first mortgage is, even though that first mortgage is going to be recorded later in time. This simply clarifies what a first mortgage is, so there's no confusion later on, and hopefully no litigation, which I've had litigation on this, so I thought it was important to include that. Finally, the last substantive section, I believe, is section 30, which is the second bullet point. Current law requires associations to make copies of the association's maintenance plan, maintenance schedule, and maintenance budget available to all unit owners and to provide those documents to the initial purchasers of the unit. This would add a requirement that these same materials are given notice to subsequent resale purchasers. So that's the walk through the bill, and with me to testify further is Attorney Tom Bray.
Senator Kreun, now that you have your glasses with you, do you want to go back and correct anything you just said?
I think I got it all right the first time, but Mr. Bray will certainly correct me if I got anything wrong.
All right. Counsel, go ahead and introduce yourself and give us your testimony, please.
Thank you, Mr. Chair. My name is Tom Bray. I'm the chair of the Minnesota State Bar Association MKIWA Committee. I've been serving on that committee for 36 years. And I think Senator Kreun went through the substantive portions of the bill. I don't really have anything to add, but if the committee would like examples or further information on any of those points, I'm happy to provide that.
Well, thank you, Mr. Bray. I understand that Senator Limmer has a question about the technical change on line 44.20. Is that correct, Senator?
Mr. Chairman, I think it was line 44.
Okay, all right.
There is no line 44, Mr. Chair.
See, a careful lawyer, you figured it out. We also have a representative for the Bar Association as a whole is present, if anyone has any questions about the process that this went through. Any questions or comments from members of the committee?
Mr. Chair, I think there was one more testifier.
Is there another testifier scheduled to join us here today? We just have Mr. Bray as the one who is signed up, but we are certainly willing to listen to anyone else who wants to add something. Come on forward, Mr. Carlson, have a seat.
Mr. Carlson, Mr. Chair, I think Nicole and I emailed about Matt Greenstein from the real property section, also providing brief comment.
Well, that's fine. If he's here, come on forward. Sir, welcome to the committee. Go ahead and identify yourself and give us your
Thank you, Mr.
testimony.
Chair. Matt Greenstein. I'm an attorney in Minneapolis at the law firm of Greenstein and Sellers.
Welcome back to Judiciary.
Thank you, sir. I'm here today to testify in support of SF 3622. As a practitioner representing common interest communities in Minnesota, a lot of these changes will benefit my clients and other legal practitioners in this area. Maye governs many different types of property ownership developments, storage condominiums, high-rise condominiums, planned communities, single-family homes, and it also overlaps with other areas of law. Chapter 317A, the Nonprofit Corporations Act, Chapter 508, the Torrens Act, 308B, the Cooperative Associations Act. So it's important when we're making changes to this section, Maye, that the language is consistent with these other areas of law, is precise and thoughtful. In going through SF 3622, I believe that this legislation is improving this statute. As Senator Kreun mentioned, there's some substantive changes that will improve the process by which associations operate. Specifically for my clients, the ability to understand the applicability, which is in section 1-102, having those exceptions carved out that the proposal clarifies. In addition, clarifying the requirements for recording amendments to documents with the affidavit of an officer to show compliance in accordance with section 2-118 is a much needed change to the statute that's been confusing both for practitioners, for the associations I represent, and for the county recorders who are trying to determine if a statute has met if an amendment has met the applicable requirements to record those documents. I also think there's corrections that are much needed and have been done through this legislation. Section 3-107 was updated several years ago to require this preventative maintenance plan, maintenance schedule, and maintenance budget was inadvertently not included to be part of the resale disclosure requirements in section 4-107. This proposal addresses that issue. And then with the overlap between the Nonprofit Corporations Act and Maye, there's been this awkward issue where 317A requires 3 board members, and in some common interest communities, you may have less than 3 members total. And that's just been a conflict between those sections of law that is now being corrected through this proposal. So in summary, I think this is good legislation. I know Mr. Bray has been working on this for some time. The language is precise, thoughtful, has consensus, I think, of all stakeholders, and addresses some issues that should be addressed.
Thank you, Mr. Greenstein. I do have a question just occurred to me about that resale disclosure requirement. That's a maintenance plan. Does it include the anticipated expenses relating to the maintenance plan and assessments on individual units to cover that?
Are you asking me, sir?
Well,
I
sure.
mean, so,
If you know the answer, otherwise we'll go to Mr. Bray.
Mr. Bray might have more detail on that, but 3-107 requires that the Board of Directors adopt a projected maintenance schedule, maintenance budget, and maintenance plan. The statute doesn't identify whether you have to allocate specific dollar amounts for each type of component, but it does require the board to have a plan in place for projected and future maintenance projects and how those projects will be budgeted and funded. So that would be part of the new disclosure requirements.
So, Mr. Greenstein, you just said and how it would be funded. So would there be a disclosure component of that that says this is how much will come out of reserves and this is how much we expect to assess against each unit in the building? Or
The statute
the
currently
association?
doesn't require that type of line item for each component.
I guess I'm not asking for each component, but at least for the overall maintenance plan.
Yes, and those things are also governed under other provisions in the statute with respect to what's required to be funded by replacement reserves what's done through operating expenses. It would also be at the board's discretion with the budget they're adopting each year.
Okay, and then the other question I have related to that, at what point in the process is such a disclosure given or required to be given?
So it can be requested by a potential purchaser at any step through the process. Once the purchaser's provided that disclosure under 4-107, Section 4-108 provides a 10-day right of rescission. So the purchaser would have 10 days to review that information, review the disclosure information that's provided by the association, have 10 days to rescind or terminate that purchase agreement for the unit. If not, they could move forward with the terms under the purchase agreement.
So what if someone is thinking about making an offer on a condominium, doesn't even want to make an offer unless they know whether or not there's a substantial maintenance coming down the road and potentially substantial assessments against the property? Can they access this information as someone who's thinking about buying a unit prior to actually making an offer or having some kind of a purchase agreement already signed?
So the statute doesn't address that specifically. There is always the right to request information from the seller. The seller would be in possession of association records. They have a right to those records under 3-118. So they could be requesting copies of the budget, copies of the replacement reserve, copies of the governing documents. They have the right to that information currently under the statute. And if a purchaser was requesting that information, the seller could certainly provide that.
So the place to get that information pre-purchase agreement would be from the seller to make that request. And
Correct.
I hope they'll give you the right information or be willing to disclose it. If they're not, I guess that's a red flag. Mr. Bray, do you have anything to add? Mr. Greenstein brought it up in his remarks, and I just, question occurred to me, so I turned to him, but you've also been working on this. Anything else I
And
should know?
Mr. Chair, I don't have anything to add. I think the existence of the requirement in the statute that there be a maintenance budget and that budget be provided as a part of this was responsive to your question.
Senator Limmer.
Thank you, Mr. Chair. Mr. Chair, as you know, I've been a Realtor for 47 years, and the requirements under law regarding the question you had of whether or not the consumer has proper information before making the sale complete. Once a purchase agreement is, and the terms are accepted, the state of Minnesota provides a 10-day review for the buyer to review not only the corporate documents, the declaration, the rules and regulations, the bylaws, and the budget of every homeowner association during the time that they're considering it. The buyer can withdraw if they find something in those documents for any reason, and their earnest money can be returned. So the one difficulty I sometimes have is not everything is in those documents, and it would be good to have a telephone number where one could call either the property management company that oftentimes takes place of the homeowner association, the homeowners that belong to that. But nevertheless, 10 days is enough time for a consumer to review those documents. And if they find something contrary to their liking, they can step away from the sale. And that's in state law.
So, Senator Limmer, you're telling me that they can get the documents, but no contact information if they have follow-up questions?
Well, Mr. Chair, sometimes that is provided through an email address. They want the questions in writing. Other times, you can find someone that'll answer a phone, but other times you may not. And oftentimes, the homeowner association members are not providing their telephone numbers. They have contracted with the property management firm to answer those questions. So it sometimes is a little bit of a hit and miss, but for the most part, I have found it to be successful in getting all of the documents that are provided that I mentioned must be provided to the buyer, and in written paper form. Oftentimes it comes through the realtors as an email, and then they pass it on to the consumer. But nevertheless, it's up to the consumer to read. Unfortunately, sometimes they're quite lengthy. It's like reading a telephone book sometimes. And they can be 200, 300 pages long at times, if not sometimes longer.
That's why they have real estate agents, I suppose, is to do the reading for
Well,
them on that
there's
stuff.
a reason why we justify our commissions, Mr. Chair.
I mean, I'm not going to interfere with the passage of the bill, but from a consumer standpoint, I mean, I would want to know this information before I decided whether to make an offer and how much to offer, rather than being forced into a position of having to rescind an already accepted offer, where I've already got money outlaid, and I've got some kind of emotional relationship to the property that I was planning to purchase, a little bit of a mental barrier to unwinding a purchase agreement. Then you're deciding, well, is this big enough to be concerned about, or isn't it, where I might not have made an offer in the first place if I'd seen some of the stuff. Is there anything in place that requires a seller, when they put something up for sale, to, upon request, disclose all of this information to any potential buyers? Or would be any complications with that? I'm not going to offer an amendment. I'm just thinking on behalf of potential buyers of condos, what I want to know and when. Mr. Bray?
Mr. Chair, there is not at this point in time, the 10-day rescission period that was referred to can be started at any time. So if a seller does not want to have a contingent purchase agreement that could be unwound, they can deliver these documents to the buyer before a purchase agreement is signed. And then the buyer has, as long as the buyer has had them in their possession for 10 days, then once the purchase agreement is signed, the purchase agreement is binding and the buyer no longer has a right to terminate the purchase agreement. I think the problem, or the perceived problem, with giving potential buyers direct access to the association to obtain these documents is that the documents, at least when the statute was drafted, the documents were primarily delivered in paper form, and the association was authorized to charge the seller to provide the copies of those documents. And I don't think sellers want sort of an open market where 100 people can call the association, request copies of these documents, and run up costs that the seller would then have to pay, even though these people may never sign a purchase agreement. So I think the idea was to make sure that the buyer had a certain level of interest in signing a purchase agreement, putting some earnest money down before the seller started to incur costs to provide these documents.
Is there any kind of a non-disclosure component if this information is shared to a potential buyer, that potential buyer can't just turn around and show it to the rest of the world, or is that a concern at all?
Mr. Chair, I don't think that's a concern because most of these are public documents anyways. The declaration is recorded. The bylaws are sometimes recorded, sometimes not, but there's really nothing confidential there. So there is nothing in the statute that requires confidentiality. Obviously, parties could contract for that if they thought it was important, but it's not part of the statute.
So maybe some food for thought for next year, so Senator Kreun has a bill to carry next spring to address, if he agrees with me, some of the concerns I've raised here today. Am I the only one that has any concerns or questions I should ask about the bill? Anyone else, members of the committee? Any other testifiers? Senator Kreun, you prepared to move forward with this?
Yes, thank you, Mr. Chair, and I'd like to thank both my testifiers and, of course, the Bar Association for all the good work that they do. It's not always easy to get all of the stakeholders together and to find consensus on some of these thorny issues, and they tend to do a really good job. And by the time it gets to this table, a lot of work's been done and we have a good product. So with that, I would ask members to support the bill.
So Senator Kreun moves that Senate File 3622 as amended be recommended to pass and be referred to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Kreun.
Thank you.
Next item up, Senator Limmer. Senate File 4115. Members, your materials on the bill are being handed out at this moment, and also you're receiving some material from the Coalition of Hindus of North America that supports the resolution that's proposed here condemning Hinduphobia. Senator Limmer, whenever you're ready, go ahead and introduce the bill, and then we can turn to your testifiers.
Thank you, Mr. Chairman and committee. I'm very proud to be the author of this particular resolution, recognizing and condemning Hinduphobia and anti-Hindu bigotry, and reaffirming Minnesota's commitment to religious freedom, inclusion, and mutual respect. Senate File 4115 is a resolution condemning such actions against the Hindu community and all forms of religious intolerance. It encourages state and local agencies, including educational and law enforcement, to enhance their understanding of Hinduphobia and to include the Hindu community in their diversity initiatives, as well as anti-bias training and interfaith dialogue. It also, at the very end, like all resolutions, it directs Secretary of State to prepare copies of this resolution and transmit them to the Attorney General, Governor, and all members of the legislature. Instead of going through bit by bit and line by line of the resolution, I'd like to introduce our testifiers today. And the first individual would be Ms. Neha Markanda and Raj Dash. And Neha will begin our testimony.
Ms. Markanda, welcome to the committee. Go ahead and just identify yourself for the record first.
Good afternoon, Chair and members of the Public Safety and Judiciary Committee. Thank you for the opportunity to speak today. My name is Neha Markanda, and I call Plymouth home. I serve as the director of the Minnesota chapter of the Coalition of Hindus of North America. I'm also a planning and charter commissioner in my city, a corporate professional. I provide Minnesota post-approved training to law enforcement and serve on nonprofit boards. Nearly 2 decades ago, I co-founded a Hindu American temple school in Maple Grove. Today, I am here as a daughter, a neighbor, and a member of this community because Hindu families in Minnesota, including my own, simply want assurance every family deserves: the ability to practice our faith openly, safely, and without fear. This concern is reflected in the nearly 400 community signatures collected in just 3 days and still growing, which is included in your legislative packet in support of this resolution. I also speak as the granddaughter of a lawyer who advocated before the state Supreme Court in India and the grandniece of the former chief of police of New Delhi, India. From my family, I learned a deep respect for the rule of law and for the responsibility we all share to protect the rights and safety of people in our community. Hinduism, the world's oldest living religion, teaches respect for all life, the pursuit of truth, and that the divine exists in every human being. The phrase Vasudev Kutumbakam translates to the whole world is one family. It shaped how many of us were raised to see our neighbors not as strangers, but as members of a shared human family. Yet many Hindus in Minnesota and across our country do not always feel that same sense of belonging. Across the United States, Hindu temples have been vandalized and desecrated. Minnesota has seen similar incidents. In Edina, a hateful speech appeared on temple grounds. Authorities noted video and other posts the perpetrator had published on social media as concerning and would be passed on to other local and federal law enforcement agencies, highlighting the potential danger to the community. In Medina, an anonymous letter opposing a Hindu temple stated that Hinduism is a false religion and that Hindu gods are false gods. In Maple Grove, the temple has faced vandalism and break-ins at priests' homes. Children have also felt the impact. Some have been teased or ridiculed in school for the food that they bring from home, for wearing a bindi, a sacred thread, or a religious pendant, or even celebrating festivals like Diwali. Others across the country encounter hateful slurs online or in public spaces, and many incidents, unfortunately, go unreported. Families may not recognize bias, may not know how to advocate for themselves, or may feel it is culturally safer to just remain silent. Hate without a name often goes ignored, and identifying and naming a problem is the first step towards solving it. Institutional recognition of Hinduphobia and support from you as Minnesota lawmakers are critical to reassuring the broader community that their pain is seen and acknowledged, and that together we uphold the promise of safety and dignity for every Minnesotan. Many of you have worked closely with immigrant communities and understand the hesitation people sometimes feel about speaking up or engaging with civic institutions like ours. Recognizing Hinduphobia is a crucial step in ensuring that Hindu families feel comfortable coming forward and using the protections already afforded to them under Minnesota law. Students are afraid to speak about their faith in class for fear of being bullied. When a temple is attacked or defaced, it is not just a building that is harmed. It sends a message that an entire community is actually not welcome. As a daughter, seeing these incidents makes me worry about my own parents. My mother is here with me today. My father is watching from home. And about families across our own community who simply want to pray in peace. This resolution is not about politics. It is about basic human dignity and the protection of religious freedom guaranteed to every American under the First Amendment. It is about whether we, as a state and as a community, uphold that promise for every Minnesotan. Minnesota is home to a vibrant Hindu community who contributes every day to this state we proudly call home. Passing this resolution will not eliminate hate overnight, but it does draw a clear line. With your support, we send a simple message to every Hindu family, every child, and every temple in our state. We see you. You belong here, and you are valued members, and that you remain protected under the same promise of dignity, safety, and religious freedom that defines Minnesota. Members of the committee, on behalf of my community, I respectfully ask for your support. Thank you for your time and for your service to our state.
Thank you, Ms. Markenda. Appreciate your testimony here today. Mr. Dash.
Chair and members of the committee, thank you for taking time to hear our community's concerns. My name is Raj Dash. I'm a father of 3 children, and I'm also the son of Dr. and Mrs. Dash. Our family has been recognized globally for our significant contributions to the world of business, social, cultural, and philanthropic endeavors. I'm here as a Minnesotan and as a member of the Hindu community. Here because many Hindu families in our state quietly carry a fear they should not have to carry. Practicing their faith openly may make them a target of hate, bigotry, and intimidation. For many people, anti-Hindu bigotry and hate may seem vague, foreign, or minor. But for Hindu families, it hits home very hard. It shows up in jokes, slurs, suspicion, mockery of our traditions, online hostility, and direct acts against temples and individuals. It often goes unreported because many in our community are taught to avoid conflict, keep our heads down, don't burden others with our problems. That silence is actually a sign of discomfort, vulnerability, and resignation. It's a creeping belief that we have to accept a less perfect America in Minnesota for ourselves than others get to experience for themselves. The concern that many Hindu families feel is also shaped by what we see beyond Minnesota. Over the last 2 years, there have been deeply troubling events internationally and across North America. For many Hindu Americans and Canadians as well, nothing is distant or abstract. They travel through family networks, WhatsApp groups, through community calls, temple conversations. They reinforce the sense that Hindus can become vulnerable quickly when society decides that their fears are really not a priority right now. November 2024, Reuters reported violence at a Hindu palace or Hindu place of worship sends shockwaves through Hindu communities across North America. Violence broke out at a Hindu temple in Brampton, Ontario. It was reported that people were striking temple members with flagpoles, throwing punches, and creating fear through religious intimidation. March of 2025, Associated Press reported that the Baptist Sri Swaminarayan Mandir in Chino Hills, California, was desecrated with anti-Hindu graffiti, and the incident was investigated as a hate crime. In June of 2025, a famous Hindu temple in Spanish Fork, Utah, was shot at 20 to 30 times. While these bullets were being shot into this temple, there were worshipers inside. For many Americans, this may seem like another ugly headline, but for Hindu families, it's a reminder that their beloved temple, a place built for worship, service, and peace, can also become a target. We do not have to look outside Minnesota. Right here in our own state, the Hindu Temple of Minnesota had their priests' homes in Maple Grove were burglarized in 2024. CBS Minnesota reported sacred and personal items were taken, contributing to a broader pattern of temple thefts across the Twin Cities. Now, it's important to understand that for a lot of Hindus, they worship at home just as much as they do at the temple, and sometimes more. So we keep very valuable religious constructs there. And when their homes are broken into, they're also breaking into their place of worship and prayer. So that's why it's very intimidating to them. When temples and homes of worshipers are repeatedly targeted, the practical result, of course, is fear, it's disruption, and a sense that your sacred spaces are also vulnerable. Now, I worry every day for my children, for my elderly parents, but also for the broader community. It's a worry that we all share, but sometimes we have to do it silently. The impact of anti-Hindu bias is physical, it's psychological, but it's also civic. It teaches children to shrink themselves, sometimes just hoping that they'd be invisible to everybody else. It makes students think twice before explaining holidays, because sometimes their friends will ask them, what's Diwali about? And they're worried about maybe being laughed at or intimidation. It makes adults wonder whether wearing visible symbols of faith will draw ridicule. It makes elders question whether the temple they visit for peace is really safe. It leaves many decent people feeling that if they speak up, they will be told that they're overreacting, or worse, they may themselves be attacked. Today, we must be willing to say that Hindu Minnesotans deserve the same respect, the same protection, and the same sense of belonging as anyone else. It's time to recognize anti-Hindu bigotry and hate whenever and wherever it appears, just as we should recognize bigotry directed at all faiths. This resolution is not going to solve everything overnight, we know that, but it does something important. It names the problem. It tells Hindu families that the state sees them, and it tells children that their traditions are not something to hide. It also tells those who traffic in slurs, intimidation, or desecration that Minnesota will not look away. The vision of a beautiful America and Minnesota we have in our hearts is equally shared by all people of all faiths. Our petition was just started on Thursday, as Nehad mentioned, in the afternoon. And this was done by us as amateurs. We didn't hire any company or group to go and make the calls for us. We did it ourselves. And as you can imagine, a lot of elderly people are somewhat technologically challenged, so to try to sign a petition electronically isn't the easiest thing in the world. But we're up to about 400 people today, and they managed to do that in just a short period of time, blizzards and everything else. So on behalf of those people, I ask everyone here respectfully to support this resolution. Please don't let this remain invisible. Hindu Minnesotans, they belong here, their rights matter here, and their safety matters here as well. So naming this bigotry also matters. Naming this hate also matters. So your support today matters so much to us, and we thank you so much for your time. Thank you.
Thank you, Mr. Dash. Appreciate your comments here today as well. Any questions from members of the committee for either of our testifiers, and then we'll turn to Mr. Roberts.
Mr.
Senator
Chair, we
Limmer.
have one more testifier, Mr.
Yes.
Ethan Roberts.
Yes. Mr. Roberts, why don't you come on forward?
Mr. Chairman, Ranking Member Limmer, my name is Ethan Roberts. I am the Deputy Executive Director for the Jewish Community Relations Council of Minnesota and the Dakotas, the consensus public affairs voice for the Jewish community here in Minnesota. I want to thank Senator Limmer for carrying this bill and Senator Latz, Chairman Latz, for granting it a hearing. We are
And
proud.
co-authoring it, don't forget.
And for co-authoring it. And I will note, I had two versions of the speech. This is the shorter version, okay?
Well played, Mr. Roberts.
Yes. So.
Very wise.
Very wise, right. Okay, so we're proud to support this resolution and stand with Kona and Minnesota's Hindu community. And really, we are just honored, Neha, that you asked us to be here today. I don't think there's anything I need to say that you and Raj didn't already say, but, JCRC, I mean, we've been here many times. Everyone knows that our mission is to fight anti-Semitism, but also to build bridges across communities. And that's why we're here, because we're not just opposed to anti-Semitism, we're opposed to religious bigotry against any community, any community that's been targeted, and clearly the Hindu community has. We as Jews know, as Hindus know, how dangerous it is when hatred is minimized, dismissed, or left unnamed. And that's why this resolution matters. It specifically names Hinduphobia, anti-Hindu bigotry. Frankly, hate without a name, it just can too easily be ignored. We also appreciate that it has the positive aspects where it recognizes the dignity and contributions of Hindu Americans, acknowledging the real harassment and vandalism Hindu institutions and families have faced, as you've just heard. I'll just close with this. At a time of rising anti-Semitism, especially since October 7th, the Jewish community has been grateful for the support of friends and allies in other communities. And in that spirit of solidarity, we are proud to be here today in support with our Hindu friends of this resolution. Thank you, Mr. Chair.
Thank you, Mr. Roberts. Any questions from any members of the committee for any of the testifiers? Not seeing any. Senator Limmer, the expected action is to move this on to the Rules Committee where all of the resolutions go. Anything else you'd like to say or present before we?
Thank you, Mr. Chair. Yes, I would like to say just a few words, and that is I would like everyone to know that this is a strong bipartisan message wrapped in this Senate resolution. I want to thank you, Mr. Chairman, for joining me on this particular resolution, Senator Kreun and Senator Hoffman. We have one room for one more, and I see Senator Westland is giving me the signal. She wants to be number 5. You know, we as a society of Minnesota has been noticing we're growing more diverse. And the Asian Indian community, and quite often with their culture comes Hinduism. When I think of the Hindus that live in Maple Grove, I keep thinking of that national motto we all have, E pluribus unum, out of many one. And quite honestly, it's embodied right here in the state of Minnesota, probably more so now than any other time in its history. We also recognize that religious intolerance seems to be on the rise across the face of the earth, but quite honestly, the only way you stop it is to shine light on it and reaffirm the very principles that unite us as a nation. So I certainly would hope that we'd have a strong bipartisan effort representing these very principles that really will unite us. Thank you, Mr. Chair.
Thank you, Senator Limmer, and I look forward to hearing the same speech on the Senate floor.
I'll try and remember.
Senator Limmer moves that Senate File 4115 be recommended to pass and be re-referred to the Senate Committee on Rules and Administration. All those in favor say aye.
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 Opposed? Motion prevails. Thank you all.
Thank you.
Thank you,
members.
Chair. Thank you, Committee. Thank you, Senator Limmer.
Yeah,
So much. It means a lot.
we'll get it done.
Senator Limmer, don't go too far. We're going to take up Senate File 3827 at this time, relating to private detectives or protective agents. All right, we now have before us Senate File 3827. Senator Limmer.
Thank you, Mr. Chair. I just was given a note that there might be an amendment, author's amendment.
Members, Senator Limmer is seeking an amendment. Does staff have an amendment to distribute?
I must have been misinformed, but
All right.
perhaps we'll get to the subject in testimony.
All right, we do have the bill in front of us, having just been distributed by staff. Go ahead, Senator, tell us what the bill's about.
This particular bill has been brought to us by the Minnesota Board of Private Detectives and Protective Agent Services. It's a revisit on particular issues. It strikes references to partnerships so that a partnership may no longer be licensed under the provisions, provides that a corporation is, if a corporation is the applicant for a license, the corporation's chief executive officer, financial officer, and qualified representative, and Minnesota manager must all meet the licensing requirements rather than just one member of the corporation under current law, and also submit fingerprints for a criminal history check. And I am going to pass the baton over to our testifier to better explain why this particular provision is necessary.
Mr. Cook.
Greetings, Mr. Chair, committee members. My name is Greg Cook, and I'm the Executive Director of the Minnesota Board of Private Detectives and Protective Agents. I do appreciate the opportunity to speak to you today. Our board has unanimously voted in support of this bill. Our board chair, Rick Hodson, has provided a statement regarding the need for this bill, and because he has a prior commitment, he can't make it today, but he does send his thanks to the committee for considering this important legislation.
Members, we do have a letter from Mr. Hodson distributed. Go ahead,
Thank you, Mr.
Cook.
Chair. I briefly wanted to highlight a few points about the need for this bill and answer any questions you may have. A very important component in the process of obtaining a private investigator or protective agent license is that the FBI fingerprint-based criminal background check be conducted to make sure we do not issue a license to someone who has been convicted of a disqualifying offense that is listed in our statute. The background check looks for certain disqualifiers as listed in those statutes and lets our agency know if the applicant meets those requirements. The actual process is separate from our agency, as it is all conducted through the BCA. The BCA first runs a statewide check, then passes it on to the FBI NCIC, which is a National Crime Information Center, to do the national check. There are currently 3 types of licenses: individual, corporation, or partnership. We have no problems with getting the FBI results for individual licenses or for employees of license holders. The FBI does have an issue with us having access to FBI records for partnership and corporate license applicants. Under federal law, use of FBI records for licensing is only allowed if there is explicit state statute language for such checks that is approved by the FBI. The FBI, more specifically, the Criminal Justice Information Law Unit, has a problem with the current language in the definitions in our statutes, specifically the term partnership. They state that it is too broad of a definition to allow access to their database. Apparently, according to the FBI, the current statutory language does not meet the standards of Public Law 92-544. The board had thought they had fixed this issue by proposing a small change to language in 2023, which you adopted and was signed into law. But the FBI has advised the BCA that for partnerships and corporate license holders, the change was not good enough to address their concerns. It was determined that the best legislative solution to this issue was to remove partnership as a type of license and remove the word partnership from our statutes. We currently have no partnerships type of license holders, and we've had very few through the history of the board. For corporate license applicants, we listed out specifically those that are signing the corporate application who would be subject to the FBI background check. By expressly listing the corporate officers that must be backgrounded. It is our understanding the FBI will finally agree to fully allow us to meet the requirements that already exist for criminal record checks under state law. In order to get these applicants run through the FBI system, we need to get the language in our statute changed, which is what this narrow bill is about. I'd be more than happy to answer any questions at this time.
Thank you, Mr. Cook. Any questions from members of the committee for the testifier? Senator Kreun.
Thank you, Mr. Chair. A question on page 3, lines 9 through 13, the changes there on the business entity applicant. And it looks like we're going from one member to, that must meet the requirements, to 1, 2, 3, 4 different members, if I'm reading this correctly. The chief executive officer, the chief financial officer, the qualified representative, and the Minnesota manager. I guess my question is, are all of the business entities that might want to apply for this license, are they going to have all 4 of those specific positions? Or I guess if this passes, they'll have to create them in order to be eligible for a license?
Mr. Cook.
Mr. Chair, Senator, so currently for a corporate license, there are those 4 positions. It's always been like that. Prior to that, we were only running the background check on the qualified representative, and if they were out of state, the Minnesota manager. This brings in the CEO and the CFO to also have a background check per the FBI.
Mr. Chair.
Senator Kreun.
Thank you, Mr. Chair. What about a company that maybe is a Minnesota-based company and doesn't operate in any other states? Would they have a Minnesota manager, or what am I missing there?
Mr. Cook.
Mr. Chair, Senator, if they're within the state of Minnesota, they do not need a Minnesota manager.
Senator Kreun.
Thank you, Mr. Chair. Is that in a different part of the statute, existing statute that says that?
That is an existing,
Mr. Cook.
Mr. Chair, Senator, that is an existing statute, excuse me.
Okay,
Yes.
thank you.
This question for council to follow up on that. Do we need to specify on line 3.11 and the Minnesota manager if there is one, or words to that effect? Or is it sufficient to leave it as is, and if that position is unfilled because it's not required, there's just nothing to be done?
Yes,
Would that be
that would be
doing it
sufficient.
again?
Yes.
Let's hear what council says.
Yes. Mr. Cook, so all corporations have a CEO, a CFO, and a qualified representative, whether they're Minnesota or out-of-state corporations, is that right?
Mr. Chair, that's correct.
So the only question might be whether or not they have a Minnesota manager, right?
Mr. Chair, that is correct, and as Senator Limmer just pointed out, if you wanted to put in the word "any" before that, it might be appropriate.
Council is suggesting perhaps after manager insert if one exists. Mr. Cook, do you think that would?
Mr. Chair, I think that works.
Senator Kreun? Senator Limmer?
I would consider that a friendly amendment.
Senator Kreun moves on line 3.11 after manager insert if one exists. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Any further discussion? Senator Western.
Mr. Chair, just a similar vein to the testifier, I think the answer is yes, but in some cases, in a small corporation, that might be the same person serving in 2 or more of those positions. Is that your understanding as well?
Mr. Cook.
Mr. Chair, Senator, one person could be in all 4 of those positions. And just to clarify that the purpose of the Minnesota manager and qualified representative is to make sure that somebody's actually involved in the day-to-day activities of the business in the state of Minnesota.
Any further discussion? Not seeing any. Senator Limmer moves that Senate File 3827 as amended be recommended to pass and be referred to the Senate floor. All those in favor say aye.
Aye.
Thank you, Mr. Chair, committee members.
Opposed? Motion prevails. All right. Thank you all. All right. Senator Maye Quade present. Senator Maye Quade is taking her seat at the testifier table as the chief author of the next 4 bills. I've given some, just to let people know how we intend to proceed here. These bills all originated in the Commerce Committee, and the Commerce Committee has the broad jurisdiction over the subject matter of the bills. Rather than wait for them to have time to hear the bills, they were removed from Commerce and sent to the Judiciary Committee because there are some provisions in each of the bills that bring them within our jurisdiction, specifically enforcement through the Attorney General's office. But none of the bills have had full consideration in the Commerce Committee or any consideration on the merits in the Commerce Committee. So I'm going to make sort of a broad statement subject to the input from the chief author. My suggestion is that when each of these are considered, that we will, other than a brief description of the broad bills themselves, that we please focus our conversations on the particular piece that brings that bill to this committee. And then because it has not even had consideration in Commerce yet, and it will be going back there from here, that any motion that is made be for the bill to pass without recommendation, so that this committee is not making any judgment calls on yay or nay on the underlying policy before the main committee has already considered it. So I'm kind of looking around. Senator Maye Quade, does that, would that be satisfactory to you?
Absolutely, Mr. Chair.
All right. Then why don't we start with Senate File 1857 relating to chatbots. Members, you may recall we did start with some conversation about this bill already. On March 9th, we did adopt the A2 amendment at that time. Let's see here. The material has been distributed to members. Senator Maye Quade, do you want to just give us a quick refresher on the content of the bill? And then I'll ask Ms. Primo just to identify for us, again, what provisions bring this specifically to this committee.
Thank you, Mr. Chair and members. Just as a reminder, this bill would prohibit companies from making chatbots available to minors, so those under 18. And I think I've actually had a chance to touch base with a lot of members between last committee and this committee to just kind of follow up on any concerns. If you want more explanation about what chatbots are, happy to do it, but I think that's the bill, Mr. Chair.
Ms. Primo.
Mr. Chair and members, looking at the A2, the main reason this bill is before this committee are the remedies and enforcement provisions on page 2, beginning at line 1.
Senator Maye Quade, do you have anything you'd like to tell us specifically about those remedies and enforcement provisions?
Thank you, Mr. Chair. Members, I will say that part of the reason Attorney General enforcement is here is because the most likely scenarios in which you would see action being brought under the Attorney General are multiple cases in one location. I'm thinking predominantly schools. So this is something that schools, whether it's teachers or administrators, notice these habits and behaviors in their students. Parents obviously would notice that as well. And then the civil penalty is mirrored, I believe, and I'll look to Ms. Primo to confirm this, but I believe it's mirrored after a similar penalty that we put into our notification bill.
Are there any questions or discussion from members of the committee relating to the enforcement and remedies provisions that are found in the A2 amendment? Senator Umu Verbetten is online, and then Senator Holmstrom.
Thank you, Mr. Chair. Thank you, Senator Maye Quade, for the bill. I'm just curious if you've given more thought to where any money from the settlements that may come through the AG's office would go. I know that I mentioned the Crime Victim Services account as a possible option, but really want to respect whatever your intentions are as an author. I just think there might be a fund that supports either, these victims, folks who have struggled with suicidal ideation, that sort of prevention work, rather than just going to the general fund. I did reach out to the Crime Victim Services Coalition that just shared some information that may be helpful for the committee as well, that 40% of folks who seek assistance through those services have attempted suicide. And the state fund that we set up, as opposed to the federal fund, does allow money to go to prevention. So it's more likely that this state fund can support that sort of suicidal prevention work. So if you're open to it, I think getting an amendment on in this committee would be helpful. But if you want to take more time to think about that or have another fund in mind, just want to raise that. Thanks.
Senator Maye Quade.
Thank you, Mr. Chair, and thank you, Senator Umova-Beyton. I think I always want to get more money to the Crime Victim Services Fund. When we did this in a previous committee, the correlation between the bill, it was the notification bill, and that fund was really clear. And in this case, I think if we were looking at a specific place in law that we wanted to direct the money to, I would think of something more like youth mental health, or there's a provision in law, it's called Aaron's Law, but it's essentially helping children identify like grooming and sexual assault attempts. That might be a place, but I also wouldn't want to put something into statute that seems like it's money going someplace and it's not. And so there's always that trade-off as well. And I think maybe what we would want to do is see, is this something where we're getting money on a regular basis, and then we put into statute where we think that money should go? I don't know if I have that. I don't know if I have that off the top of my head at the moment.
Senator Umova-Beyton, follow-up?
Thanks, Mr. Chair. Yeah, that makes sense to me. Just keep me posted on what you're thinking as the bill moves along, and if this does pass, right, and then we have an opportunity to see if there's funding coming in, and then want to direct it to an account. I'm here to help. Thanks.
Thank you.
Senator Holmstrom.
Thank you, Chair. Senator Maye Quade, the effective date is January 15th, and then there's this transition period. I guess my question is, if I'm a company that's offering this service, and there is a child harmed between now and January 15th, the language of a chatbot available to minors must begin decreasing services in a manner that does not harm minor children. Can you define what that harm looks like?
Senator Maye Quade.
Thank you, Mr. Chair, and thank you, Senator Holmstrom. It's a really good question. The reason we've included the transition period is researchers have identified the possibility that having a start cutoff date could actually be more detrimental to young people than a gradual transition. There was reporting, I think it was today or yesterday in the Wall Street Journal, that as ChatGPT considered this like adult mode, they weren't considering any, which is like very explicit content that you could do with ChatGPT. There were no other like, age verification measures, and so they were like looking at this method, they call it like this new age method, I think is what the Wall Street Journal called it, and they were misclassifying minors as adults like 12% of the time. And so I would look at this date of this, January 15th, 2027, as like for a company like that, that's how long you have to get this new age model right. And in the interim, as you start to identify people as minors, decreasing the services, putting, whatever parameters you need into place so that there's no harm when services end completely on January 15th.
Thank you.
Any further questions or discussion? Right, not seeing any. Senator Clark moves that Senate File 1857 as amended pass and be re-referred to the Senate Committee on Commerce. All those in favor say aye.
Aye.
Opposed? The motion prevails.
1886.
All right, members, we're going to jump on the agenda to 1886. So Senate File 1886. The staff will hand out the materials. And Senator Maye Quade, same thing here. We're going to take a brief description of the bill as a whole, then we're going to focus in on provisions that bring this bill before the committee, which should be included on page 2, subdivision 5 of the bill, remedies and enforcement. Senator Maye Quade.
Thank you, Mr. Chair and members. Senate File 1886 is actually a pretty simple bill. This bill would just require that there's disclosure if a person is interacting with AI for the purposes of a conversation. So in a text conversation or a oral conversation, they just have to be notified. And then there has to be the option for an opt-out or to engage with a person. So a really good example, there was a video I saw last night of a woman calling Hilton in Texas, and she wanted to know, is the pool open at this time of year? And because she was talking to what Hilton calls a live agent, but actually AI, it didn't quite understand the question. And for 3 minutes, she was just like, can I talk to a person? And it took that long for the live agent to admit that it was in fact AI and then transfer to a real person. And so this is the kind of stuff that happens all the time. These voices are, almost indistinguishable from real human beings, but the consequences can be quite high. We had that happen in my own family with a medical appointment for an emerging cancer, and the AI made the appointment at the wrong location, and we were delayed by a week getting that checked out. So just disclosure and the option to talk to a human if available.
Senator Maye Quade, I don't have any particular testifiers identified to testify in support of the bill. We do have someone signed up to testify opposed to the bill. That's Jarrett Catlin, who I believe is online.
Thank you, Mr. Chair.
Mr. Catlin.
Thank you, Mr. Chair. I appreciate the opportunity to testify. I'll tailor my comments to focus on remedies and enforcement provision. Our main concern is that the enforcement structure in this bill is disproportionate, that this bill would create a private right of action with statutory damages of up to $1,000 per violation plus attorney fees, and that the Attorney General can bring enforcement actions and penalties up to $5 million. Given how broadly the disclosure obligation is written, the exposure here could be enormous. This could include a chatbot created on a website, an AI-drafted email, an AI-suggested reply. All of these arguably involve an individual communicating or interacting with AI. And so since that every undisclosed AI interaction is a potential violation, a single business could face thousands of claims for routine use of common tools, and the size of these penalties would incentivize opportunistic litigation. We think AI disclosure is a conversation worth having, particularly in higher risk contexts or specific situations like companion chatbots, but are concerned that the enforcement structure here is disproportionate. Thank you for your time.
Any questions for Mr. Catlin from members of the committee? Thank you for your testimony. Any other, I will note, members, there's also a memorandum that was distributed by staff in opposition to the bill as well, relating to the provision on private right of action. Senator Westrom.
Mr. Chair, just in response to the testifier, Senator Maye Quade, any response you have to that or concerns or thoughts? Have we found the right balance? We don't want to over-incentivize frivolous actions or opportunistic legal procedures, but we also want to strike the right balance. Any thoughts you have?
Senator Maye Quade.
Thank you, Mr. Chair. And Senator Westrom, thank you for the question. I feel like when the testifier was testifying, there was this little sweeping remark of like any interaction, but it's actually, if you look on line 1.14, it's a conversation. So it's not, an email that used AI-generated phrases that was still sent by a person. Those were chosen by a person. The person responding to the email would be reaching a person. This is when an individual person is having a conversation with AI. It just has to be disclosed. It's not for, fraud detection or sorting, or if you used AI to create your billboard, although I do think they should disclose that, but this law would not apply to that. It's for conversations, which we, understand to be an exchanging of ideas back and forth.
Senator Wood.
Mr. Chair, is there maybe an enhancement of defining conversations that we need to look at? And I don't know, just a thought as we're kind of talking through this, but I appreciate your response.
Senator Maye Quade, any follow-up there?
Thank you, Mr. Chair. I'm not, I know there's plenty of words in law we do define, and I don't know how granular we get. I don't know if the common understanding of conversation suffices, but that was what my intention was.
Any further discussion? Senator Holmstrom, then Senator Kreun.
Thank you, Chair. Senator Maye Quade, so you have an opt-out provision that, let's see, I'll read. A person who uses artificial intelligence in the course of business must provide an individual with the option to communicate or interact with an actual human instead of a computer. So first question is, the use of AI and computer seems to be interchangeable throughout here. Do we need to be more clear about that, or do you feel as though that it's clear enough that computer equals AI?
Senator Maye Quade.
Thank you, Mr. Chair. Senator Holmstrom, can you point me to the line you're on?
2.3.
Senator Holmstrom.
Thank you.
Senator Maye Quade.
Thank you, Mr. Chair. I think we could refer back to artificial intelligence, if that feels more clear.
Senator Holmstrom.
Thank you, Chair. I think that would be a good idea, just to clarify throughout the whole bill. Then with the opt-out, there are certain businesses that it makes a lot of sense for, right? My health insurance company, things like that. But when I think about if Home Depot does this to me, I can just go to Menards, So I don't know if an opt-out, it might be cost prohibitive for a lot of companies. They're obviously implementing this so that they don't have full-time employees. And a lot of them in the business of commerce, they might just choose that they don't care about that customer enough to hire somebody. Do we need to legislate that on them?
We'll go down this path a little bit, but I just want to remind Senator Holmstrom.
Fair enough.
Within this committee, we're going to focus on remedies and enforcement. Of course, it's enforcing the entire bill, so there's some value to clarity. But in terms of getting to the policy part of it, that's the province of the Commerce Committee. We're going to leave it to them.
I won't have a follow-up.
Okay, did you want an answer to the last question?
Sure.
Senator Maye Quade, briefly.
Thank you, Mr. Chair, and thank you, Senator Holmstrom. I think, the reason I put that opt-out is because if you are a company that's saying, we're going to engage in a conversation with you about something, AI hallucinates constantly. They get things wrong. They don't have, they know what, they don't know why. And so if you're trying to provide a service in a conversation, there should be a human on the other end of it. And if you don't have that ability, then you don't have that ability. But I would argue like AI with no human is actually worse.
Any further discussion, Ms. Primo? I'm sorry. If we go back to address what Senator Holmstrom mentioned, Ms. Primo, do you have a remedy, a clarification of language? Why don't we tackle that first, and then we'll go to Senator Kreun.
Mr. Chair and members, computer appears twice in the bill, so the amendment would be page 1, line 19, delete a computer, insert artificial intelligence. Page 2, line 3, delete a computer, insert artificial intelligence.
Senator Maye Quade, what do you think about that?
Mr. Chair, I think it's totally appropriate. I can actually recognize my own speaking pattern as reflected in this bill. This is probably how I spoke about it out loud.
Senator Holmstrom, what do you think about the proposed amendment?
I think that is acceptable.
Senator Holmstrom moves adoption of the amendment as described by council. Senator Westrom to the amendment.
Mr. Chair, to the amendment to the bill that's being amended, just wondering to the author, did AI draft this bill, do you think?
Can you tell the difference is the real question. All right, to Senator Holmstrom's motion to adopt the amendment as described by council, all those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Kreun.
Thank you, Mr. Chair. Staying on the opt-out section, in your testimony, I heard you say that that the person must be able to opt out and interact with an actual human instead of a computer, which has now been amended, if available. Yet I don't see the words "if available" anywhere in the opt-out provision. So what am I missing?
Senator Maye Quade.
Thank you, Mr. Chair. I apologize if I was unclear. For the purposes of this bill, if somebody is engaging in a conversation, then yes, there should be the option to speak to a human. Otherwise, there is no conversation that could be had. You're just putting inputs into AI.
Senator Kreun.
Thank you, Mr. Chair. I mean, I think I can imagine scenarios where a business chooses to do this and doesn't have a human customer service representative available. And, you know, I think we're kind of making an assumption here that it's, you know, that it's a Home Depot and that they have customer service reps and that they're just using AI to supplement and somebody can opt out and then they can get right to one of those human customer service representatives. But I don't know if there's other scenarios where that doesn't exist. So I just, you know, what happens if they don't have, if the business doesn't employ any human customer services representatives? How are they supposed to comply with this?
Senator Kreun, I really want to keep this focused on the Judiciary Committee jurisdiction relating to remedies and enforcement, not to the other policy provisions in the bill that the Commerce Committee will consider. Do you?
I appreciate that,
tie
Mr.
this to
Chair.
our jurisdiction here?
Well, a business would be liable for significant damages here if they violate this opt-out provision, and the opt-out provision doesn't seem clear to me. I guess unless the testimony is just that it's strict liability and anybody who uses an AI chatbot must have a human customer service representative available. If that's the testimony, then I guess that's the testimony. But I was wondering if there was some carve-out based on the testimony that Senator Maye Quade gave at the outset.
Senator Maye Quade, is there a carve-out or is it an absolute must-have human? Senator Maye Quade.
Thank you, Mr. Chair. I think we might want to just broaden our understanding of what actual human means for the context of this. So it doesn't mean that if I'm typing to, let's say, Home Depot and it's an AI chatbot, they've disclosed that, and the AI chatbot just for whatever reason cannot understand the type of return I'm looking to do, I can opt out and send an email, right? I can call, it doesn't mean that I have to go to immediately a person that replaces that chatbot in that moment in that text. It just means I have to be able to communicate or interact with a human about whatever I'm trying to communicate about. So having an email option, perfectly acceptable. Having a, phone service or a callback or whatever, perfectly acceptable. But imagine right now that we only have AI to deal with for anything from very mundane, like I need to make a return, to I need to schedule this appointment with several specialists, and at no point in time can you say, I need to talk to a human in some way to get this done because AI doesn't understand what I'm asking. And that could be out money because you can't make your return at Home Depot. It could mean you don't get your cancer treatment on time because it doesn't understand that, yes, I know I live in Apple Valley, but I'm actually closer to the Blaine location and want to be seen there. And so the consequences are so high, and all of consumerism is predicated on the fact that when you do business with a company, you have to be able to either continue or undo that business. And if they're just putting AI in between it with no option to interact with that company, then what are we doing?
gradations, you know.
Well, I think it's with the option to communicate, or when does the option present itself?
Yeah.
How does the option present itself? Is it buried in the fine print somewhere?
I like all of this. I like disclosure. The opt-out stuff. Sounds like they're trying to litigate it.
So, sounds to me like there's a bit of a policy dispute, but in terms of the language providing clarity as to what would or would not be required by the law, that seems to be clear. Either there's a human option, online or not online, in person, or there isn't. Now, whether or not that is a good route to go from a policy standpoint, I suggest we leave that to the Commerce Committee to discuss, or a floor debate when we get to that point. Fair enough, Senator Kreun?
Thank you, Mr. Chair.
Remember, I'll be a
guess I'll-
motion to pass without recommendation.
I hear you. Thank you, Mr. Chair. I guess I would just say it's not clear to me, but I appreciate the Commerce Committee can further dive into that, but the option to communicate, like, what does that option look like? When is it presented? Where is it presented? I think there's a lot of questions. If that's for the Commerce Committee, then maybe somebody will watch this and they can jump into that. I'll move on to my final area here.
Senator Kreun, I'm sorry to interrupt. I was going to suggest, if you think the language is not clear to implement the policy that Senator Maye Quade intends to implement, and you have a suggestion to clarify the language so that it's clear what is or is not a violation that would lead to enforcement or remedy, then please suggest some language.
Mr. Chair, I appreciate that. I'm debating how prescriptive that option could be. Maybe one idea could be strike the in 2.2 and replace it with N, A-N. Because I don't know what the option is. N option makes more sense to me.
Every word has meaning.
What this is.
Ms. Primo? Thoughts?
Mr. Chair and members, in addition to the amendment proposed by Senator Kreun, perhaps it would be helpful to include on line 2.3 before the period, comma, including through electronic mail or an audio or video call.
Mr. Chair,
Or in person?
only if there's a but not limited to.
Ms. Primo? Would you read your full suggested remedy here?
Okay, the full amendment would be page 2, line 2, delete the, insert N. Page 2, line 3, before the period, insert including but not limited to through electronic mail or an audio or video call.
Ms. Primo, would that include a in-person option, or if we're going to list some things, maybe include in-person in there? I mean, it works if it's Home Depot, you can go into a bricks and mortar. If it's purely an online, then it's not less likely to be available, but at least that would be clear.
Yes, Mr. Chair,
Ms.
we
Primo.
can include something to that effect. Yes, I might need just either a little time to put that all together, or if I can get some technical, like some authority to technically make it work, that might be helpful.
Okay, well, Senator Westrom has a question as well. Oh, no, Senator Kreun had a third point. So while we turn to that, Ms. Primo, why don't you give some additional thought to this?
Thank you, Mr. Chair.
Senator Kreun.
And forgive me if I stray into commerce here. I think it does link to the
I
penalties here.
might not forgive you.
I'm going to proceed anyway and then ask for forgiveness rather than permission. So the deceptive conduct, subdivision 3 on page 1, it's talking about how if the person misleads or deceives a reasonable individual to believe that the individual is engaging with an actual human, and then it says and then there's two options below there, which is with an or. So one of the way is if, and then the first one's a negative, so it's really hard to follow. But when you put it all together, if the individual is not notified in a clear and conspicuous manner that the individual is communicating with the computer, or the individual reasonably believes the individual is engaging with a human. My concern with that is that you could have, a company could have clear and conspicuous notification that the person is not communicating, or that the person is communicating with a computer, yet still run afoul of this deceptive conduct just because of the way that this is structured. I would like to see, if you're gonna want to go down this road, that if you have clear notice that the person is speaking with a computer, that should be enough. But under this, it's not necessarily enough. They could have that, yet if the person still reasonably believes they're engaging with a human, they could be liable. Now, I guess reasonably is still in there, so there is some comfort language, but to me, it should be perhaps an and or something, so that it's clear that if the company puts conspicuous notice that they're not engaging in deceptive conduct.
Senator Maye Quade.
Mr. Chair, thank you, Senator Kreun. I'm very amenable to that. Mr. Chair.
Senator Maye Quade.
Thank you, Mr. Chair. I think the suggested change, and correct me if I'm wrong, Senator Kreun, is on line 1.19, strike the or and put an and.
Thank you,
Senator
Mr.
Kreun.
Thank you, Mr. Chair. That's initially what I was thinking. If council can maybe indicate if that would get, if we made that one minor change, if that would get at the intent.
Ms. Primo. Multitasking here.
Mr. Chair and members, yes, I think I caught what the intent of that change would be, and changing or to and would make it so that in order to be liable under subdivision 3, both of those clauses would have to be met or demonstrated.
Thank you, Mr. Chair.
Senator Kreun.
Thank you, Mr. Chair. I still think it's a little inartfully worded, but for purposes of substantive purposes, I think that would get at what I'm saying. So that way, if the company or the individual in this case notifies the person in a clear and conspicuous manner that they are communicating with a computer, then the person could not meet the elements of deceptive conduct. So I think an oral amendment on changing or to and on line 1.19 would be good.
Senator Maye Quade, to that proposed amendment.
Thank you, Mr. Chair. I'm very amenable to that, and I thank you, Senator Kreun, for giving it the once over. I don't draft my own bills, but I can commit to working with council to maybe work on the artfulness of the language.
Senator Kreun, do you move on line 1.19 to delete the word or and insert in its place the word and? Any further discussion? All those in favor say aye.
Aye.
Opposed? Motion prevails, the amendment is adopted. Before we move on to Senator Westrom, Ms. Primo, do you have any follow-up to our Senator Kreun's previous point? Or shall we give you more time?
Mr. Chair and members, yes, I have an amendment for the
Please
committee's.
describe it.
Page 2, line 2, delete the, insert N. Page 2, line 3, before the period, insert including but not limited to communication or interaction through electronic mail, an audio or video call, or an in-person meeting.
Senator Kreun, what do you think about that proposal?
Thank you, Mr. Chair. I think it improves the bill.
Senator Maye Quade.
Thank you, Mr. Chair. I think the only method of communication we might be missing there is text. Maybe it could be, message or something.
Ms. Primo.
Sorry.
To that point. Senator Holmstrom, to that point. Okay, Ms. Primo.
Mr. Chair and members, I wonder if instead of electronic mail, we could insert electronic messages, and that maybe hopefully captures email plus text.
Mr. Chair,
Senator Kreun.
maybe just electronic communication.
Mr. Chair and members, yes, electronic communication.
With those changes, Ms. Primo, could you read the full proposed amendment to us?
Mr. Chair and members, I'm just making a little technical adjustment based on that. Yes, page 2, line 2, delete the, insert an. Page 2, line 3, before the period, insert including but not limited to through electronic communication, an audio or video call, or an in-person meeting.
To that proposed amendment, Senator Clark.
Yes, Chair, and Senator Maye Quade and Senator Kreun. So I may be the only one who's commissioned an AI chatbot at their other job. And one of our fundamental principles, and we have the AI code of conduct at my other company, that you have to have an opt-out that includes human interaction. And what I'm listening for here is to make sure that there is a human at the other end. And that, I think, is what we're trying to get at in this. So while Ms. Primo is going through this and we're considering, does it, I think in each of these, whether it's, you got a DM, you got WhatsApp, you got whatever it happens to be, that are we giving enough, latitude that whatever comes next, whatever the next tool is, that it's, whether it's sliding into DMs, whether it is a text message or email, whatever it is, that is allowed in this. So there just needs to be a human at the other end is, I think, what we're all agreeing on here.
So Senator Clark, on line 2.2, it does make reference to an actual human, and then describes some means by which that might happen after the, at the end of line 2.3. Does that address your concerns?
Chair Latz, yes. It's just I was trying to, but each step, does that still have a human at it? And each one that I think Ms. Primo has described and Senator Kreun and Senator Maye Quade has added still has a human at the end, so yes.
Senator Maye Quade?
Thank you, Mr. Chair. And my thoughts had been closer to Senator Clark, so I was like, what about what's next? But I think as long as, whatever mode or method people might communicate, as long as there is a human at the other end of that communication, I am fine with it. And the option to have it at some point, it doesn't have to be in that moment.
Senator Holmstrom, to this proposed amendment or not? Yes. Senator Holmstrom.
Thank you, Chair. The one thing that this amendment isn't addressing, in my opinion, is the time frame that it can be offered at a later time. I would like to see language long within a reasonable time added to this. Just I worry that there's an immediacy expectation, and I would like to apologize to the Corporation of Home Depot for continuing to use them in this advertisement.
You're going to be trespassed pretty soon.
But of course, they have business hours, and at midnight, they might not be able to meet that expectation, but they certainly could during business hours.
Chair.
Senator Clark.
To Senator Holmstrom, Chair Latz, to Senator Holmstrom's point, my other job, we also have the mail option. So literally, you are able to mail to a central point. So I think we have to, before we go too far down into what is reasonable, we know that there are those individuals who might need mail. So I'm chewing on that now.
Mr. Chair.
Senator Maye Quade.
Thank you, Mr. Chair. I don't know if I want to necessarily be specific. I think all types of businesses are all types of ways, and it might make sense for some to have a person immediately ready to take over a chatbot, right? Like Amazon is one that comes to mind. They might be able to just have a person do it. One might be like, I'm going to direct you to our nearest location. They're open at these times, and here it is. Or someone might be like, I can call you right now, right? And so I wouldn't want to start putting time limits in there, because I think without it, we just make it clear that there has to be an option. And then however that option fits into your business, that's how it fits into the business. Maybe it's send this letter to this person.
I think we might want to be careful we don't get into what might or may not be a good business practice as opposed to what could lead to a violation of law and damages. If I'm running a business, I probably want to be as prompt as I can, but if that's not an option or not part of my business practice, then I'm not sure I'd want to be held liable because I didn't fit into someone else's notion of what a good business practice should be. Senator Holmstrom, thoughts?
Yeah, to that point, my worry is just that somebody might get upset at 1 o'clock in the morning when they choose to do their, whatever the business is, and file a complaint with the AG that could lead to damages because there is not a time frame or any reasonableness listed in the bill. If I'm upset at 1 o'clock in the morning because insert major hardware store brand doesn't respond to me right away, I just don't want that to lead to damages.
Well, if you're doing that work at 1 o'clock in the morning, I think your expectations have to be adjusted. But be that as it may, did you want to propose an amendment, Senator Holmstrom, or you just want to leave the comment for the record at this point and we can move on?
Yeah, I think we can chew on it and let Commerce figure it out.
All right, so we have Ms. Primo's proposed language for an amendment. Does anyone need it reread, or have we heard it enough? All right, Senator Kreun moves adoption of the amendment as described by Ms. Primo. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. All right, let's see here. Senator Kreun, you've covered your points. Senator Westrom, did you? You don't have anything in this one. Okay, is there any further committee discussion on Senate File 1886 as amended? All right, Senator Clark moves that Senate File 1886 as amended pass without recommendation and be re-referred to the Committee on Commerce. All those in favor say aye.
Aye.
Opposed? The motion prevails. Yeah, so members, we're just trying to adjust the agenda and the schedule here. So we have, Senator Maye Quade has a hard stop at 3 o'clock because she has another committee to get to. Is that correct, Senator Maye Quade?
I would imagine if my legislative assistant has told your CA that, then yes.
Okay, we also have Attorney General Ellison here present for the ghost gun bill, which is under my authorship. We have the option of taking, what I'm going to suggest that we take up the ghost gun bill now, and then if we have time, we'll come back to the other Maye Quade bills. If she needs to leave before we complete them, then we can reconvene fully remotely at 5 o'clock. That way we can get through the agenda today. We're simply running out of time to push bills off to another committee hearing. So let's do that. We're now going to take up Senate File 3661. We're going to pass the gavel to Senator Pappas.
Have her come over here.
Senator Pappas will come to the gavel. I get a copy of my bill. Okay.
Senator Latz, welcome to your committee.
Madam Chair,
You want
thank
to
you so
proceed
much.
with Senate File 3661.
I can't imagine a more seasoned gavel wielder than Senator Pappas to take over chair at this time. Members of the committee, this bill is returning. This topic is returning to this committee. The legislature did at one time pass a prohibition on creating, possessing, owning a ghost gun, which is a firearm that does not contain a serial number. Unfortunately, the language, it turns out, was, according to a court, irreconcilably in conflict with federal statute on the topic and was invalidated. So we have returned now. The Attorney General's office has worked on language that we, for purposes of reconciling it and allowing it to cohabit with federal law, and that's what you have before you. I do have one author's amendment relating to effective dates, so I'd like to move the A1 technical amendment as an author's amendment.
Okay, the A1 amendment is being passed out. Just wait a second while that's being passed out. I got it. Are there any questions on the A1 amendment? Author's amendment. Senator Latz moves the author's A1 amendment. All those in favor say aye.
Aye.
Opposed,
Aye.
nay.
Aye.
I was for yes, and I oppose nay. Sorry to those online. I'll remember to pause a little bit. Motion prevails. Senator Latz.
Thank you, Madam Chair. The author's amendment there made all the applicable provisions effective for crimes committed on or after August 1st, which is the standard effective date when we create crimes. And I think the basic premise of this bill is clear. The idea is that firearms need to have serial numbers. Sometimes they show up at crime scenes, and there's only one way to identify and track firearms. That's by a serial number. The bill provides a number of ways to accomplish that. And beyond that, I'm going to let the Attorney General describe what he wishes to. Those are reasons for the bill.
Welcome, Mr. Attorney General. Please introduce yourself for the tape and then proceed with your testimony.
Thank you, Senator Pappas, and allow me to thank also Senator Limmer and all members. And I'd like to inform the committee that a staff member of mine is joining us at the table, Eric Baloney, who has done extensive work in this area. I'm here to testify in favor of House File 3661 that Senator Latz has introduced to prohibit the creation, possession, and sale of ghost guns. Its companion, House File 3407, is authored by Representative Pinto. Allow me to just make clear about why this bill is necessary at this time. Although the Minnesota statute, section 609.677, already bans removing or altering serial numbers from a firearm, a recent Minnesota Supreme Court opinion found that the Minnesota statute only requires firearms to have a serial number if the guns were required to be serialized under federal law. By tying Minnesota's current statute to constantly changing federal regulatory standards that currently do not outright ban or prohibit all ghost guns, this ruling has created a significant and I believe dangerous loophole in the state law that I respectfully submit requires urgent attention. As you know, ghost guns are firearms that can be 3D printed or assembled at home from kits sold online. Ghost guns present a clear and present danger to Minnesotans and our public safety for 3 reasons at least. First, ghost guns make criminal investigations more difficult. Ghost guns lack serial numbers that traditional firearms have, rendering these guns untraceable, which can significantly impede law enforcement investigations. Second, ghost guns bypass background checks. It can take an hour or 2 to 3D print a ghost gun or assemble one from a kit purchased online. When that happens, the background check process is bypassed entirely, allowing dangerous individuals who cannot pass a background check to acquire a gun. Third, ghost guns remove a major deterrent for gun traffickers. Serial numbers on traditional firearms deter individuals from gun trafficking, that is, illegally selling firearms to other people who are legally prohibited from owning a gun. If firearms with serial numbers that are recovered at a crime scene can be traced back to someone who claims to no longer own them, law enforcement may begin investigating that individual for gun trafficking. The lack of a serial number on ghost guns makes it harder to identify who sold or trafficked the firearm. Let me give you a real-life example. On October 2021, Markeisha Wiley was shot and killed at the Truck Park restaurant in St. Paul. It's walking distance from here. The guns used in that shooting were not ghost guns. They had serial numbers. Because of that, law enforcement was able to track down the store that sold the guns used in the shooting. This led to investigators to a guy named Jerome Horton, who purchased one of the guns at the that was used at the Truck Park shooting. Horton, who had also purchased 32 other firearms in a very short period of time, was trafficking guns. He then resold many of those guns to individuals who are not legally allowed to have guns. Because the guns in that case had serial numbers, law enforcement was able to catch and stop the straw buying scheme that put people's lives in danger and actually was the scene where Markeisha Wiley lost her life. Jerome Horton went to prison. The people who shot at the Truck Park restaurant are doing life in prison. But if a ghost gun was used, it would be untraceable, and that may not have been possible. The availability and untraceability of ghost guns is a growing problem in our own state. In the 5 years from 2017 to 2021, 187 ghost guns were recovered at crime scenes in Minnesota. In the 2 subsequent years of 2022, 2023, 631 ghost guns were recovered at crime scenes, an over 600% increase. Behind those numbers are heartbreaking stories. In September 2024, 16-year-old Care Reed from Chaska was accidentally shot and killed by a friend using a ghost gun, likely assembled from a kit ordered online. In July of 2024, a teenager was shot and killed in a drive-by shooting. The weapon used was a ghost gun. In August 2022, a ghost gun was found at the scene of a shooting where over 40 rounds were fired and a 17-year-old was shot dead. Senator Latz's bill proposes common sense solutions for closing Minnesota's ghost gun loophole. Senate File 3661 prohibits the sale, purchase, transfer, possession of firearms without serial numbers. It requires individuals without federal firearm licenses to obtain a serial number before completing the manufacture or assembly of a firearm, frame, or receiver. It caps at 3 per year the number of firearms, frames, or receivers that an individual can manufacture without a federal firearms license. It requires individuals to bring unserialized firearms or unfinished frames or receivers to dealers with federal firearm license or other federal licensees who are authorized to provide serial numbers. And it restricts the use of 3D printers to manufacture firearms and prohibits the distribution of design files used to 3D print firearms. This important legislation is also in good company. The common sense regulation or prohibition on the manufacture, sale, and possession of ghost guns is already on the book in 15 states and District of Columbia. This bill also has some common sense exemptions to protect the rights of gun owners. Antique firearms are exempt in this bill, as are guns manufactured before 1968. If you just moved to Minnesota, the bill gives you some time to get the serial numbers added to any unserialized firearms you may own. And if you're an amateur gunsmith, you can still manufacture firearms just as long as you get them serialized by the people who do so. These safeguards were built into the bill just to ensure it doesn't infringe upon the rights of law-abiding gun owners, of which I am one. I can assure you that we're not looking to just jam people here. We really are not. We're trying to save lives and solve crimes. What we're doing is adapting to a world where technology allows someone to 3D print many of the components of a fully functioning firearm in their living room. Senate File 3661 stands on firm legal ground and on firm moral ground. I urge you to stand with law enforcement, the many victims, and advocates supporting it for the health and safety of all Minnesotans in every community in our state.
Thank you, Mr. Attorney General. Are there any questions for the Attorney General? Senator Bergstrom.
Thank you, Madam Chair. Attorney General Ellison, so it's my understanding that FFLs are defined and regulated by the federal government. So do we have a state, any form of a database of who is an FFL that could do this work and who we would have to track?
Attorney General Ellison.
Thank you for the question, Senator. The serial numbers are routinely assigned and stamped on guns. It's something it's a practice that's done in our state. The individuals who need that service have 6 months to get it. But I'm not aware of the database that you mentioned. I know that the ATFE does monitor and regulate FFLs. FFLs for everybody else is federal firearm license. So.
Senator Bergstrom.
Thank you, Madam Chair. So I guess my primary question is, do we have jurisdiction over them to mandate this? And then if a member of law enforcement finds a gun that has a serial number, how do we track it back to that FFL if they're just coming up with a number?
Attorney General.
Thank you. Senator, the way the serial numbers are set up is that the first digits on the serial number are unique to the FFL, and that is something that is in the possession of the federal authorities. And that is how these are normally done. The first digits on the number are, they know who to go call and call on. And then, that is how these numbers are traced back. For example, in the truck park shooting incident, that's what they did. They traced the gun back, and that's why I wanted to provide you all with that example.
Did you have another question?
Nope, that answered my primary question. Thank you.
Thank you,
sir.
Excuse me. Mr. Maloney, did you want to add anything?
Thank you, Madam Chair. To Mr. Holmstrom's last question, Senator Holmstrom's last question, I guess, just to add on to what the Attorney General said, that it's a relatively new rule change at the ATF to allow FFLs to do the serialization process on their own. And like the Attorney General said, it is predicated on the first few digits always tie back to a certain FFL, and it's kind of meant to decentralize the marking process to allow gun shops to kind of help supplement the marking process so that more firearms can get marked.
Okay, I think we have a couple other testifiers for right now. Senator Latz, if we can proceed with that. Let's invite Mr. Brian Ghosh and Ms. Anna Leamy to come forward. Oh, Brian's on Zoom. Okay. Mr. Ghosh, did you want to start out?
Yeah, can you see and hear me okay?
Yes.
Okay, well, my name is Brian Gosh. I'm a lawyer and registered lobbyist for the National Rifle Association, here today to testify against Senate File 3661. A lot of times when people refer to ghost guns, they really conflate three issues. One is the undetectable firearm. Two is the personally made firearm, could be at home. And the third is manufacturing of a firearm or major components with a 3D printer. To the first issue, federal law already bans undetectable firearms, however they're manufactured, made, or whoever may possess them. The federal law has been in place since '88. There's been several reiterations since then. They've been against the law. They're still against the law. There's a security exemplar that requires at least 3.7 ounces of stainless steel be used in the manufacture of firearms or major components. And so that they cannot be undetectable, particularly to airport metal detectors or other metal detectors. And for the major components, they have to be in the shape of that major component and detectable as they go through there. A penalty provision for this is 5 years in prison for any undetectable firearms. And typically, if a firearm is made from something that's not metal, that is not a very effective firearm anyway. It's usually ineffective. On the second issue, for the personally made firearm, for centuries in this country, that's been allowed, even prior to America becoming America. And under the United States Supreme Court hearing decision in New York State Rifle Pistol Association versus Bruin, a 2022 case, for gun control to be valid, it has to comport with the nation's history and tradition for firearm regulation. And like I said, for centuries, personally made firearms have been allowed. And that's without government regulation for serial numbers and manufacturing type restrictions like 3D printers. Now, if a person attempts to transfer that firearm, then it's going to have a serial number. The last one is the 3D printer portion of it. Many products in America today are made with 3D printers. A lot of aerospace technology, auto parts, medical equipment like hips and knees, dental equipment are made with 3D printers. Some are metal parts, some are non-metal parts. The way something's manufactured shouldn't matter because regardless, if you are a prohibited person and you're possessing, selling, or trying to manufacture, it's already against the law. You can go to prison for up to 15 years. ATF, federal law allow individuals to make firearms. You know, one of the other issues that I noticed in this bill, amongst others, was in the section of 4.7, how it defines assembly and then putting together these firearms. It limits it to 3 per year for individuals. Well, if you're a person who uses firearms and you routinely exchange uppers and lowers for the type of use of your firearm, you're going to be limited to doing that 3 times. And so that's going to be unreasonable for how Minnesotans use and enjoy firearms. So for that reason and others, I would stand by for questions this time and urge you to oppose this bill. Thank you.
Any questions for the witness? Senator Bergstrom.
Thank you, Madam Chair. Does your organization work with any FFLs and might be able to give us some answers on that front?
Well, certainly.
Mr. Gosh.
I'm sorry, Madam Chair. Yeah, certainly that would be the case. And we can get you some additional information for the committee if you would like.
Senator Bergstrom.
Thank you, Madam Chair. So the question that I have is what would you expect an FFL to charge for this type of a service?
Mr.
I would have
Gosh.
to get back to you. I'm sorry, Madam Chair. Yes, I'd have to, doing this via Zoom, I sometimes forget the protocol, so I apologize. Yes, I can get that information to you.
Thank you.
And Ms. Sleemy.
Madam Chair, members of the committee, my name is Anna Leamy, Director of Government Relations and Advocacy for the Minnesota Gun Owners Caucus. Rather than solely targeting violent criminals, Senate File 3661 expands criminal law to regulate the activities of ordinary gun owners. Senate File 3661 would make it a felony to possess an unserialized firearm, even if it was lawfully manufactured and possessed under current law. Owners would be forced to either serialize the firearm through a federally licensed dealer, surrender it to law enforcement, or render it permanently inoperable. For generations, Americans have lawfully built firearms for personal use. Federal law has long allowed individuals to manufacture firearms for themselves as long as the individual is not selling the firearm. Senate File 3661 would make many of these privately manufactured firearms illegal to possess in Minnesota if they do not have a government-approved serial number. People who legally built firearms in the past could suddenly become criminals. By effectively prohibiting private firearm manufacturing unless performed by a federally licensed manufacturer, Senate File 3661 criminalizes conduct that has historically been lawful. Senate File 3661 also raises serious First Amendment concerns by criminalizing the distribution of digital files used to design or manufacture firearms using 3D printing or CNC technology. Courts have repeatedly held that computer code is protected speech under the First Amendment. Criminalizing the distribution of digital design files raises significant constitutional concerns. Minnesota already has extensive criminal laws addressing violent offenses, illegal firearm possession by prohibited persons, and misuse of firearms. Expanding the criminal liability for law-abiding citizens engaged in historically lawful conduct does not better serve public safety. For these reasons, I respectfully urge you to vote no on Senate File 3661.
Thank you for your testimony. Are there any questions for Ms. Leamy? All right, then, Senator Westrom.
Madam Chair, I guess Just maybe for the author, while the testifier is still there, but Senator Latz, is it your intention that the private party that the testifier is talking about would have to get Social Security or a serial number on all of the guns that they make? How is your bill going to interplay with the concerns that the testifier raised? Maybe that's a better way to ask the question, and people that have done this for years.
Senator Latz.
Madam Chair, Senator Westrom, yes, it's my intention that all firearms be serialized. That's the only way to trace them in the event their firearm is used in the commission of a crime. And I don't think that there are any infringements on any of the constitutional rights, certainly not under a theory that firearm possession and manufacture can be reasonably regulated.
So, Madam Chair.
Senator Westrom.
To the testifier, I guess, can you give us some more response to that issue? And I guess, you know, I run across constituents from time to time that I mean, they're gunsmiths, it's kind of their hobby, all growing up. How does this not violate the Constitution? I guess in your statement, it sounds like you think that is. Second Amendment says shall not be infringed. Senator Latz, you're saying basically you can't do this, the testifier. Is that your position or concern that you're speaking about? Is the private operator that's making a gun themselves doesn't always wouldn't want to do this, or it would infringe on their right? Can you explain a little more your thoughts or where you think the concern is?
Senator Westrom, I'm sorry, who are you asking to comment?
I think it's Annie.
Is it the witness? Oh, okay, Ms. Leamy.
Madam Chair, Senator Westrom, yes, that is our concern, that this would negatively affect ordinary peaceable gun owners. If that answers your question.
Follow up, Madam Chair. Do
Senator
you have
Westrom.
any idea, and maybe it's hard to estimate this, how many people may participate in helping develop their own gun or create their own gun? Do you have any idea? And maybe that's an unfair question. If you do, if you don't, that's fine.
Ms. Leamy, do you have any idea?
Madam Chair, Senator Westrom, I do not have those numbers, but that can be something that we can provide to you if helpful.
Any discussion or other questions for Senator Latz? Senator Kreun.
Thank you, Madam Chair. I'm just wondering if Mr. Ghosh is still online. I thought of a question for him if he is.
Looks like he is.
Yes, sir.
Thank you. Mr. Ghosh, I want to make sure I heard your testimony correctly, because I am sensitive to the gun trafficker situation or problem that we heard in testimony from the Attorney General. But did you say that it's already illegal under federal law to transfer one of these ghost guns, so-called ghost guns, without a serial number? Put another way, before you transfer it to somebody else, you have to get it serialized under federal laws. Did I understand that correctly?
Mr. Gosh.
Thank you, Madam Chair, and thank you, Senator Kreun. That would be correct. If it's a personally made firearm, before you can transfer it or sell it, you'd have to get it serialized. And just a reminder again that regardless of how it's made, if it's an individual manufacturer, prohibited people are prohibited people, and they cannot own, possess, sell, or use firearms.
Madam Chair?
Senator Kreun.
Thank you, Madam Chair, and thank you for that response. So if I'm understanding this correctly, the gun trafficker that is going to use a ghost gun and transfer it to a third party, that's already illegal under federal law. So what this is really getting at is people who manufacture the gun for their own personal use. That would require them to serialize that firearm or face significant criminal penalties. Am I understanding that correctly?
Madam Chair,
Mr. Gosh and then Senator Latz.
I'm sorry, was that question for me?
Yes,
If it
that question was for you,
yeah.
Mr. Gosh.
Thank you, Madam Chair. I would say the answer is yes to that.
Senator Latz.
Madam Chair, Senator, many of the firearms that end up being trafficked are stolen. They're stolen out of parked cars, and quite frequently, apparently. And I've heard something like 15% of the firearms that are out there being floated around or transferred were stolen. You still can't trace them if there isn't a serial number on them. So if we really want to be able to enforce the anti-trafficking laws there, I think we need to have serial numbers on there. I'll also note, creating a category of ineligible persons who can't possess firearms. If you want to use the word infringement in its broadest and most strict terms, that's an infringement too. What the Constitution recognizes is that there are some boundaries around it. There are some limits to what is considered to be unconstitutional infringement. This bill does not prohibit someone from self-manufacturing a firearm at all. They just have to serialize it.
If there are no questions for Ms. Leamy, then I can invite her to leave the witness table and we can proceed with our conversation. Thank you very much. Senator Westland.
Thank you, Senator Pappas, and this may be something that Attorney General Ellison can speak on as well, but it's actually my understanding that the Supreme Court in Bondi v. Vanderstock actually upheld the regulation of ghost guns. So we keep hearing about things that are unconstitutional, but it's my understanding that that court decision was a 7-2 court decision regarding regulation of ghost guns. So I don't know, again, if Senator Latz or A.G. Ellison have anything to add to that, but, or phone another friend.
Madam Chair, Senator Westland.
Mr. Maloney.
Thank you, Madam Chair. So Senator Westland, to your question, the Vanderstock decision did come out from the U.S. Supreme Court last year. That decision involved it was a rule from the ATF, the federal agency that regulates firearms, that basically expanded the scope of federal law to cover, if you've ever heard of a polymer 80, it's like a ghost gun made from parts kits. And the Supreme Court basically upheld that rule. So yes, you are correct that the constitutionality of at least those set of regulations have been ruled upon and found constitutional by the Supreme Court.
Okay, is there any other discussion, any other comments? Senator Burstrom, then Senator Westrom.
Thank you, Madam Chair. Senator Latz, so we talked about, you spoke about stolen guns being trafficked. How would serial numbers on those stolen guns help at all in combating trafficking?
Senator Latz.
Madam Chair, as Senator Holmstrom, one would know where the gun started before it got into the stream of stolen commerce.
Senator Holmstrom.
Thank you, Madam Chair. According to the ATF, a significant number of trafficked guns just have their serial numbers scratched off because we know criminals don't care about the law, which is already covered under state law. So if we're going after trafficking, this gun or this legislation, I guess I don't know how it's more actively combating that. Can you outline that for me?
Senator Latz.
Well, Senator Pappas, Senator Holmstrom, I think to say that because a subsequent crime could make it more difficult to trace the firearm doesn't mean we shouldn't be taking the steps necessary to try to trace that firearm. Scratching off a serial number may or may not be incomplete. There may be some way to identify some portions of a serial number if it's not done to completely obliterate the serial number. There may be other ways to track it, but I don't think we should use a subsequent crime as a justification for saying we shouldn't attempt to prevent the trafficking of firearms.
Senator Holstrom.
All right, and then I guess another question about constitutionality. If I'm creating my own gun, I'm milling out aluminum to create a receiver and turning it into a firearm, my total cost on that gun could be as low as $300 or $400, depending on quality. If I hire an FFL to do a background check, the last time I did a background check at an FFL, it cost me $45. And then they also have to do gunsmithing, which is going to require, let's see, at least an hour's worth of work. Bill that out between $50 to $100 an hour. I would expect my bill to be somewhere between $150 and $200 for the total cost. If you're mandating that this is done, or the gun has to be rendered inoperable, is that not a Fifth Amendment violation, a constitutional taking? Because you're mandating the gun is destroyed or turned in.
Senator Latz.
Senator Pappas, if a person manufactures a gun that they know is going to be subject to certain regulatory requirements, and they put themselves in the position of having to incur the costs of complying with those requirements that they knew before they incurred the costs of manufacture in the first place, it's not a taking. I can't imagine any world in which that's the taking.
Yes, Senator Holmstrom.
Thank you, Madam Chair. Correct, once moving forward. However, we know that these guns are widely in use by hobbyists. These already exist today, and this, of course, doesn't create a grandfather clause for them, only if they purchased the gun before 1968. So what do you say about the constitutional taking of their property now, once this law is put into effect?
Senator Latz.
Madam Chair, Senator Holmstrom, there's no confiscation of the firearm. There's just an additional regulatory cost to continue to possess it. I don't see that as a taking within the constitutional sense, and I'm not sure what to do with the numbers that you threw out because I don't have a basis for questioning that. But I mean, you seem to ask the NRA whether or not they had any numbers on that, and they didn't have any at hand. But even if it amounts to 10% of the, or whatever the cost ends up being of the cost of manufacture, well, there's some things that you bring into this world you just have to expect are going to be regulated. If you already possess it and you've got to bring something into compliance, let's say you currently possess an illegal machine gun, and the law says you got to turn that machine gun in. I don't see any environment in which the legislature or the Constitution would say that it's a taking if you're turning that in, or if it's taken from you by the government.
Senator Holmstrom, then I'd like to move on to Senator Westrom.
Sure. And of course, I would agree if I owned an illegal weapon that is currently legal today, I would expect that to be taken away. We're talking about guns that are legal today, and I would argue that, of course, if you're restricting the use and enjoyment of my property, that is an illegal takings. Now, I'll leave my questions for a later date, I guess, moving forward if we want to move on. Thank you.
Senator Westrom.
Madam Chair, I'm sorry, before we go there, to further amplify on the answer to Senator Holmstrom, Mr. Maloney can identify some portions of the bill that ameliorate some of those concerns.
Mr. Maloney.
Thank you, Madam Chair. Senator Holmstrom, I don't think it's been discussed today, so I wanted to raise two aspects of the bill for you to consider thinking about the concerns that you raise. One is the grace period. So there is a grace period built into the bill for current owners of unserialized firearms to come into compliance. There's a few different ways that they can do that, but the bill says from the effective date of the legislation that they have 6 months to come into compliance. So I think the bill is not drafted as a gotcha where on day one law enforcement would come knocking on your door. There is 180 days built in for them to come into compliance. The other piece that's in there is the Department of Public Safety is not going to be directly involved in marking firearms, but they are mandated under the bill to issue a public notice that I believe goes to FFLs to, I think, both let them know about the passage of the bill and that they can provide marking services to persons who need them. So I think those are just two things that haven't come up yet today that are built into, I think, both to accommodate the needs of current owners of unmarked firearms.
Are there any more questions or just discussion? Senator Westrom.
Madam Chair?
Senator Westrom.
Madam Chair, if Mr. Senator Latz, a question for you, and then Mr. Gosh, I'd just like to get his perspective as well. But Senator Latz, where do you draw the line? What can government impose on requirements? A serial number, so you can't traffic it. Can we impose the color of the guns that are made? Can we impose the size? Can we impose the metals that are put into it? Where do you think the line is drawn before you get into a violation of the Constitution?
Senator Latz.
Senator Pappas, I'm not going to get hypothetical here as to what the Constitution might or might not allow. The bill provides for serialization, and that's where I'm going to leave it.
Madam Chair.
Senator Westrom.
So Senator Latz, the reason that it's kind of important is we need to know where is the constitutional line drawn. We all take an oath to uphold the Constitution, federal and state. I'd like to know where you think the line is drawn, but we got your answer. Mr. Gosh, I guess I'd just ask for your perspective on the same thing and what would stop the state from mandating all guns to be orange or all guns to be a certain color or made out of a certain metal. Where does the line get drawn? Mr. Gosh, if you could give us your input for the committee's consideration.
Mr. Gosh.
Thank you for the question, Senator. I think, honestly, it's a difficult answer to give, as Senator Latz expressed to some extent as well, because honestly, to some extent, it depends on who the governing body is at the time and who's on ultimately the U.S. Supreme Court at the time and how they determine our rights in this category or any category. So, but current state of the law is that's not something that's regulated, that they don't regulate color and things like that. And so my testimony today pertained to the bill that's before us and the parts of it that I thought would go too far under current law and how it's interpreted.
Mr. Gosh.
Senator Westrom.
How do we prevent traffickers or evildoers or lawbreakers from erasing serial numbers on the guns? Is that something we can do?
Madam Chair.
Mr. Gosh, I don't know if you want to respond to that, but you can certainly give your opinion.
Right. I think it's a difficult area to do because as lawmakers, you set boundaries in many categories for people. And of course, many people follow them, but there are some who don't. And so it goes to the root question of how do you stop evil? How do you stop people from breaking those laws that the body sets here? And that's a difficult question. And I think it's something that lawmakers have tackled for centuries.
Okay. Is there any other discussion then from members of the committee? Then Senator Latz, would you like to make your motion?
Thank you, Madam Chair. I move that Senate File 3661 as amended be recommended to pass, be re-referred to the Senate floor, and I ask for a roll call.
Senator Latz moves that Senate File 3661 as amended be recommended to pass and sent to the Senate floor, and a roll call has been requested. The Secretary will take the roll.
Senator Latz.
Yes.
Vice Chair Umer Verbatim.
Yes.
Senator Limmer. No. Senator Clark. Senator Holmstrom.
No.
Senator Kreun. Chair Pappas.
Yes.
Senator Seeberger.
Yes.
Senator Westland.
Sorry, we do this every time. Yes.
Senator Westrom.
No.
Senator Clark.
Yes.
There being 6 in favor, 4 against, the motion prevails, and the bill will be sent to the Senate floor. We'd like to invite Senator Maye Quade back to finish her last 2 bills. Hopefully she's around somewhere. They have 2 more?
Senator Maye Quade, which of your remaining 2 bills would you like to start with?
Mr. Chair, let's start with Senate File 1856.
All right, Senator Maye Quade, the materials are being handed out to members of the committee. If you please go ahead and describe Senate File 1856. And again, members, the plan is to focus our conversation on, well, I guess the whole bill, since there is going to be an amendment that deals with enforcement, to focus on those provisions and then to move it to pass without recommendation. Senator Maye Quade.
Thank you, Mr. Chair and members. This is a short but very impactful bill. This bill would prohibit the use of artificial intelligence from being used in the utilization review for health insurance claims. That means the review, evaluation, determination, or appeals processes. Members, this bill initially came to me as an idea to have AI prohibited in the use of denials. And you probably hear from the health plans today that they would prefer if the bill was actually just not allowing AI in use of denials. But here's why it's the entire utilization review process. Recent reporting and recent lawsuits have alleged that health insurance companies use AI to mass sort or review cases, send them to providers who can deny claims in 1.2 seconds. So I was reading an article and it said in the 24 seconds you've been on this page, Cigna's doctors could have denied 29 claims. In fact, over a period of 2 months in 2023, Cigna doctors denied 300,000 requests for payments using this method where they either batch deny or bring it all the way to denial and then have a person hit deny. One former doctor said, we literally click and submit. It takes all of 10 seconds to do 50 at a time. And so members, AI, the insurance industry is built to deny claims. That is its purpose. And so allowing a technology tool that A, hallucinates, is not always accurate, and B, has no parameters around privacy concerns, to aid in the faster denial for our health insurance claims is just unconscionable. And so with that, members, I know we have an author's amendment. I know we have some testifiers, but I hope I can get your support on Senate File 1856.
Senator Maye Quade, you have the A2 amendment, which would be an author's amendment. Is that correct?
Yes, Chair Latz, yes.
All right, Senator Westland moves adoption of the A2 authors amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. We'll go to the first testifier that we have identified here is signed up, Dr. Laurel Reese. You are on Zoom, so please introduce yourself and tell us what you'd like to say.
Good afternoon. Thank you, Mr. Chair and members, and I appreciate you rescheduling to get us in today. My name is Dr. Laurel Reese. I'm a family physician here in St. Paul. I work right up the street. I'm currently at the hospital waiting on a baby. I'm representing the Minnesota Medical Association, and I'm testifying in strong support of Senate File 1856 as amended. The Minnesota Medical Association has, as you know, done a lot of work on prior authorization reform, advancing a lot of legislation in 2024, which went into effect earlier this year. But one thing that we did not yet address was the use of artificial intelligence in utilization review. It's our position that if there is an adverse determination, that decision should be made by a reviewing healthcare provider of the same or similar specialty, not a computer, not AI, denying or delaying care based on an algorithm. We have extensive data showing that prior authorization is a huge burden for both patients and physicians. 70% of patients say that prior authorization is burdensome, and the majority say that prior authorization is the top barrier in receiving care. I'm going to say that again. Prior authorization is the top barrier in receiving care. For our members, 94% of physicians say that prior authorization delays access to necessary care. 82% indicate that patients abandon care when jumping through the hoops just gets to be too burdensome. And nearly 1 in 4 physicians reports that prior authorization has led to serious adverse events, including death, permanent impairment, and hospitalization. The decisions that are being made by AI are not small decisions. They are decisions that impact people's health and their lives very directly. And these are decisions that need to be made by human beings with brains, not by computers and AI. We appreciate the opportunity to testify today and are happy to answer any questions.
Thank you, Dr. Reese.
Thank you.
I don't have any identified testifiers in addition to Dr. Reese. So let's see if any members of the committee have any questions for our testifier or Senator Maye Quade. Senator Maye Quade, I know I've had some conversations with you offline about this. I think my questions are mostly Commerce Committee related questions, not enforcement related questions. So I'll save most of my inquiry for Commerce Committee, where I also serve. But just as you know, before I go any further, Senator Seeberger has indicated she has a question. Senator Seeberger, or a comment.
Thank you, Mr. Chair. I find myself in the position of once again defending the insurance industry. And while I appreciate Senator Maye Quade's bill, and I do agree that there is an interest in having an actual human practitioner review claims, I want to push back against the assertion that the insurance industry is built to deny claims. I think that's inflammatory and false, and I would love to have an actual conversation about the problems of prior authorization, unfair denials, without having it framed as an entire industry set up against their policyholders. I appreciate this bill. I do think this is a discussion we need to have, but I would prefer that we have that discussion based on facts rather than inflammatory language. Thank you, Mr. Chair.
Thank you, Senator Seeberger. Senator Maye Quade, the questions I was going to raise have to do with whether there is any appropriate role for AI to be used in the screening or review of claims as they come in. Many claims end up being approved. The ones that get an adverse determination and get denied, might be flagged by AI for physician review as an alternative way to look at it. not only, you know, so that there is a human that does review the entire file, even if it's flagged for proposed denial by AI. So it's that human eye and mind that makes that final decision. And of course, if AI is used in any aspect of the decision-making process here, even summarizing or reviewing or trying to highlight any particular points or concerns in a file for a physician to review it, then they would not be able to attest that AI was not used in the utilization review process at all. So basically, it would be cutting out AI from any involvement in the process. And that may well be your purpose, or it may well be something that needs to be evaluated down the road. But I'm highlighting these concerns now so you have an opportunity, and any members of the public that are looking at this have an opportunity to consider these concerns before it comes up in Commerce Committee. So no one will be surprised when I start raising these questions in the Committee of Jurisdiction over these issues. Senator Maye Quade, any follow-up on that before we resolve the matter?
No, Mr. Chair, I mean, I think we can save a lot of these conversations for Commerce. I think for purposes of this committee, you know, I do think that there are certainly privacy concerns related to having third-party AI companies having access to our health data, whether it's identifiable or non-identifiable. I did ask the health plans that I met with in anticipation of this bill if they could send me contract language that ensures that our health data is actually not being used to train the large language models. I wasn't sent any. And I think that, you know, I agree in principle that, you know, used neutrally, there could possibly be a role, but there's no way to allay the data privacy concerns and the fact that as it's currently being used, as it's currently being deployed, AI is being used to rapidly deny claims and then present providers with the health insurance company, you know, a batch of denials that they look at for 1 second and then deny. So they've technically met the criteria of the law, but not the spirit of the law. As I know lawyers like to talk about. And the last thing I would add is that AI is notoriously unreliable. If you listen to the head of Anthropic talking about the parameters that he wanted to put around Anthropic being used with the Department of Defense, is that, you know, it hallucinates things, it makes things up all the time. And so imagine that you are a person who had their health information summarized by AI and it made up a condition or misstated a condition, and you were denied for that reason. We do need humans at the helm, especially when it comes to our healthcare, Our human bodies are interesting and people are interesting, and there's lots of things that a human might know that AI might not know. And it's hard to go back and unwind that. And so I do think that we should have, you know, humans at the helm of our healthcare, whether that's providing it or whether it's reviewing our health insurance claims. And it's why I just don't think AI in its current form, the way it's been rolled out to consumer-facing AI, belongs in health insurance review. And again, we've just seen the evidence of how it gets rolled out. So maybe in practice it could be good, but how it's being used is not.
So Senator Maye Quade, you raised the issue of privacy. Of course, this is not government data, so there's no Chapter 13 implication here. That would leave privacy concerns or data to the Commerce or Health Committees, since that's the kind of data that we're talking about here for a more broader policy discussion. Another idea might be to put a sunset date on this restriction, so it forces us to return to the conversation when there's more experience about the use, and as AI becomes better, one might think or hope, or more accurate, one might also consider whether there are some other guardrails that can be put around the system that would force humans to be more actively involved in evaluating these decisions, rather than banning part of the process for reviewing it. But these are all interesting conversations, I find, but we'll better head in the Commerce Committee. So I guess having broken my own rule, I guess I'll pull myself back at this point.
Mr. Chair?
I do support the Attorney General's enforcement authority, so that's, I think, where we're going to land here.
Mr.
Senator
Chair,
Maye Quade,
I'm not
final
sure
words
if
before we vote.
the government's data includes the government's public insurance data that is provided to Minnesotans, but that could be a consideration for you and if you're thinking about privacy concerns.
Well, not seeing anything in the bill specifically that addresses that at this point. I think that's beyond the scope of our work here today. Any further discussion before we entertain a motion? Not seeing any. Senator Westland moves that Senate File 1856 as amended be pass without recommendation and be re-referred to the Senate Commerce Committee. All those in favor say aye. Aye.
Aye.
Opposed? Motion prevails. All right, next up and last on our agenda here today is Senate File 3098. Senator Maye Quade.
Thank you, Mr. Chair, and please allow me to flip to my very large book. I'll try to keep this short since I know we're pressed for time. So imagine, Mr. Chair, that you and I are going to enter a pie contest. Tomorrow, we're going to bring in our pies to see who have the best pies, and we're going to do French silk. And so we're going to order right now from Target all the ingredients we need to make French silk pies because we don't have them at home. And so we pick up our phones, we order from the same Target down the street, Midway Super Target, the same ingredients for the same pickup time on our way home. But you, Mr. Chair, are charged 13% more than me for the exact same ingredients from the exact same store ordered at the exact same time. This is called surveillance pricing. Retail companies, consultants are applying AI models with all of our personal data and with billions of dollars of investment to find personal prices to figure out how much we are willing to pay for an item and charge us that. And to be very clear, this is not the pricing based on market forces, supply and demand, location, cost, transport, or the cost and value of a good plus a little profit. Again, this is pricing based on you, and it's tailored to find the maximum amount you will pay. This is something that is already happening right now. I'm not 100% sure if the Chamber of Progress letter was submitted to this committee, but in it, they admit that they have all the data they could need to do this. So if a store has enough data about you to send you an individual coupon for $2 off of a product you regularly buy, they have enough data about you to individually mark up that same product because they know you're going to buy it. So, Mr. Chair, this bill would ban surveillance pricing and end this personalized pricing. There's also stuff on wage price or wage discrimination as well, and we have definitions of that. I'm happy to go into it. I had like 3 pages of opening remarks, which we don't have time for. But I will just say that this bill does not prevent companies from offering discounts to consumers. It does not prevent companies from offering discounts to common groups of people like veterans or teachers. And it doesn't prevent them from offering memberships and discounts to customers that aren't individualized pricing based on consumer surveillance data. So, Mr. Chair, that is my bill. There is, I believe, an author's amendment, which is a delete everything that gets the bill into the shape we would all want it in.
Senator Pappas moves the A1 amendment as an author's amendment. All those in favor say aye. 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 Opposed? Motion prevails. I do have a question about the author's amendment. I'm just scanning it through here. Is there the Attorney General enforcement provision in the delete everything amendment? And if so, can you point out where it is?
Mr. Chair, I believe.
Senator Maye Quade.
Thank you, Mr. Chair. I believe that the presumptive violations is what puts this into your committee on line 4.13. And I would look to council to correct me if I'm wrong.
Ms. Primo.
Mr. Chair and members, yes, the reason this is before this committee is because of subdivision 5 on page 4. And I believe because of where this language is codified in 325D.141, that there is, it triggers enforcement language that's in current law, and then these presumptions would apply in those various proceedings.
Thank you, Ms. Primo. I encourage members to read through the presumptive violation language carefully so that we can be as precise as we can on that. I don't have any testifiers. Oh, we do have testifiers identified. Let's see here. We'll start with, there's a pro testifier, owner of Moon Palace Books, Angela Schwanettel. Note here, she can't make it, or she could not stay with us this long. We also had Jarrett Catlin from TechNet. Looks like he may have already left online as well. Do we have Will Hagan from the Minnesota Retailers here remotely? Is Will here? Or in person, even better. Come on forward.
Chair Latz and members of the committee, thank you for the opportunity to testify. My name is Will Hagan, Vice President of Minnesota Retailers. Our members, ranging from small independent stores to regional and national retailers, compete every day to earn the next customer visit. At the core of retail is a simple truth. Success depends on offering the best value, not the highest price. Retailers do not win by charging more. They win by staying competitive. And in today's environment, that competition is intense. Today's consumers can compare prices instantly and switch stores easily. If a retailer prices too high, customers leave, sometimes permanently. In that way, competition itself is one of the strongest protections for consumer affordability. Retailers do not use pricing tools and digital systems for one purpose: to remain competitive and deliver value. Importantly, these tools are not limited to large companies. Local retailers across Minnesota use digital pricing tools to respond to changing supplier costs, manage inventory, reduce pricing errors, and offer promotions. Digital pricing systems allow retailers to respond efficiently to shifts driven by supply chain, the global market, and tariff changes, helping control costs and maintain affordable prices at the shelf. Retailers support the principle that consumer data should not be used to unfairly raise prices. That's a reasonable concern. However, we're worried that this bill would go much further and could limit retailers' ability to use data to lower prices and provide savings. For example, many retailers offer personalized coupons based on purchase history through voluntary opt-in loyalty programs. Consumers choose to enroll because they want discounts. These programs are designed to deliver savings, not increase prices. SF 3098, as amended, also applies broadly to automated decision systems and defines wage to include scheduling, task assignments, and incentive structures. Retail workforce systems are designed to align staffing with customer demand and ensure stores operate efficiently. This bill should also be considered alongside Minnesota's existing consumer data privacy law. Finally, the broader policy context matters. To date, there's not been a widely established record of pervasive surveillance-based pricing abuses in retail stores. I'll end by saying we appreciate the goal of protecting consumers, and we support transparency and fairness. Affordability is driven by competition, efficiency, and the ability to adapt. We should be careful not to unintentionally eliminate discounts, increase costs, or restrict tools that help deliver savings to customers. Thank you.
Thank you, Mr. Hagan. Any questions for Mr. Hagan while he's at the table? Not seeing any. Thank you. You may return to your seat. Thank you. And Jonathan Cotter, Chamber of Commerce. Come on forward, Mr. Cotter. Go ahead. Thank you.
Thank you, Mr. Chair. Mr. Chair and members of the committee, my name is Jonathan Cotter, Director of Healthcare and Commerce Policy with the Minnesota Chamber of Commerce. Thank you for the opportunity to share the Chamber's concerns with Senate File 3098 as amended. First, I appreciate the opportunity to meet with Senator Maye Quade and discuss the goals of this proposal and the concerns we are hearing from businesses and employers. At the outset, I want to be clear that the Chamber does not believe consumer data should be used to unfairly raise prices, and we believe consumers and employees should be treated fairly in the marketplace. However, our concern is that Senate File 3098 goes well beyond addressing that principle and instead creates a new set of regulations that could sweep in routine business practices companies use to compete for customers in the marketplace. For example, the bill's definition of automated decision systems is broad enough that it could apply to common pricing and inventory management software used by many businesses. Across the economy, employers rely on digital pricing and analytic tools to respond to changing costs, supply chain disruptions, inventory levels, and shifts in demands. These tools help businesses reduce pricing errors, manage inventory more efficiently, and offer promotions or discounts to consumers. They also support consumer programs such as loyalty rewards, coupons, and other voluntary discount programs. While the bill includes certain exemptions, the Chamber remains concerned that the interaction between the bill's broad definitions and those exemptions could make it difficult for businesses to determine whether many common pricing and promotional tools comply with the law. The committee may wish to more clearly distinguish between different pricing practices in the bill's definitions so that efforts to prevent surveillance-based pricing do not unintentionally capture routine practices such as cost-based pricing, dynamic pricing, personalized pricing, or voluntary discount programs. Explicit safe harbors for those practices could help provide clarity for businesses. Thank you for the opportunity to share these concerns. We look forward to continuing to work with the author and the committee to ensure any legislation addresses unfair practices while preserving the tools businesses use to compete and provide savings to consumers. Thank you.
Thank you, Mr. Cotter. Any committee discussion now relating to the, oh, did we have another testifier? Who's here? Eid Ali. All right, are you present? In person. Come on forward. Please go ahead and identify yourself and your affiliation and let us know what you have to say.
Good afternoon, Mr. Chair and members of the committee. My name is Eid Ali, and I am the president of Minnesota Uber and Lyft Drivers Association, also known MULDA. Thank you for the opportunity to speak today. Rideshare drivers are an essential part of Minnesota's transportation system, yet many are facing financial hardships. Recent enforcement actions have sharply reduced businesses for these drivers, and a large portion of this workforce is immigrant and people of color, making them especially vulnerable to economic disruptions. While we support the goal of fair and transparent pricing for consumers, it's also important that Senate File 3098 does not unintentionally reduce drivers' ability to earn a living wage. These drivers rely on this work to support their families and contribute to their communities. We respectfully urge the committee to consider amendments that protect driver earnings, ensure economic stability, and maintain equitable opportunity for Minnesota's rideshare workforce. By doing so, we can achieve a balance between consumer protection and the livelihood of those who make the system function every day. Thank you.
Thank you, Eid Ali. Appreciate you being here. All right, that's all the testifiers we have identified on this bill. Is there any committee discussion specifically to the violation provisions in subdivision 5 that brings this bill before this committee? Senator Pappas.
Just a quick question. I'm not familiar with this presumptive violations. So does it mean that it's presumed to be like a misdemeanor, or what is the violation?
Senator Maye Quade or Ms. Primo, if you know the answer. Ms. Primo.
Mr. Chair and members, the statute would be, it's under current law, it's 325D.15, and it does include a misdemeanor for any person that violates this section. And then it also includes bringing an action, and that action may be brought by any person damaged or who is threatened with loss, damage, or injury because of the violation. And they can have injunctive relief as well as actual damages.
Thank you.
Senator. Ms. Primo, is there Attorney General enforcement in 325D as well or not?
Mr. Chair and members, no, there isn't, except under the Attorney General statute, under 8.31 subdivision 1, the first sentence is sort of broad about the authority to bring actions related to unfair practices and something of that nature. It's possible that could be interpreted to apply to some of these statutes that are in 325D. I think that would be maybe up to the AG to determine whether they feel that they have the authority. Just want to flag that, but not directly in 325D.15.
Thank you. Any further questions or discussion? Not seeing any. Senator Maye Quade, any final thoughts before we bring a motion?
No, Mr. Chair, thank you so much for spending a considerable amount of your committee time on my bills this year. They're very important, and I appreciate the thoughtful conversation from the committee on all of them.
Senator Pappas?
Mr. Chairman, I would just move that Senate File 3098 is amended,
Pass without recommendation?
Pass without recommendation. Thank you. And sent to the Commerce Committee.
All those in favor say aye.
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 Opposed? Opposed? Motion prevails. Members, our next hearing date is Wednesday, March 18th, 12:30, here in this room, capital G15. We are adjourned.